All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 27th, 2024. We have 20 bills on the docket, and we're going to start off with House Bill 892 with Delegate Kaufman. Delegate Kaufman, welcome. The floor is yours.
Well, thank you, and I will try to be brief because I know Delegate Edelson has a 1:15 voting session. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed colleagues. For the record, I'm Delegate Aaron Kaufman, representing District 18, Montgomery County. You may know my senator. I am requesting a favorable report on House Bill 892, benefits exploitation. This issue was brought to my attention by Baltimore Council Member Chris Burnett. HB 892 would reclassify the exploitation of an individual for their benefits and expand Maryland statutes criminal law 8-524. This bill passed out of the House Judiciary Committee by a vote of 20-0 with no unfavorable votes. HB 892 passed on the House floor by 137-0 with bipartisan support. The bill also has the support of the Baltimore Mayor Brandon Scott, the Baltimore City Council, the Prince George's County Council, the Maryland State's Attorneys Association, and the Baltimore Jewish Council. In fact, the bill does not have any opposition. Benefits exploitation, this is the amended term as the bill started with the term of benefits trafficking, is the systemic recruitment, harboring, neglect, and financial exploitation of elderly or disabled adults who receive government benefits, such as Social Security, Veterans Benefits, SSI, Medicaid, Medicare, SNAP, TANF, pensions, benefits, any other form of public assistance. Individuals often pose as kind-hearted individuals offering to provide care for at-risk adults in in-home settings, things like assistance with maybe bathing or eating. Once recruited, however, at-risk adults are stripped of their government benefits, often held against their will, moved from location to location, and denied basic needs such as food, clothing, and adequate shelter. While benefits exploitation is a basic civil rights issue, it is also a growing public health issue. Victims of benefits exploitation are often forgotten at-risk adults who have fallen through the cracks of various mental health systems, are unhoused, or no longer have a social support system in place. And I didn't come up with that. That's courtesy of the renowned National Institutes of Health. This bill would prohibit a person from knowingly recruiting, harboring, or transporting a person for the purpose of taking their government benefits through force and or underhanded practices. Benefits exploitation causes detrimental harm to individuals and their families and is deceptive and predatory behavior. This needs to be stopped, committee. 23 other states have reported instances of this crime, and Georgia has already passed it. Let Maryland be a leader and pass the bill to protect our most vulnerable citizens. I ask for a favorable report on House Bill 892. Thank you very much. I'm happy to answer any questions.
Excellent. Thank you very much, Delegate Kaufman. Questions from the committee? Senator West.
Thank you, Mr. Chair. I just want to compliment the delegate for bringing this bill. I think it's a very important bill. I'm really surprised that we don't have something like it on the books already. So congratulations. I'll look forward to voting for it.
Thank you, Senator West. To have a mentor like you say such kind things makes my day.
See, JPR can be a great place, you know? All right. Further questions for the delegate? Excellent. All right. Okay. Well, thank you very much, Delegate Kaufman. Thank you very much.
Thank you. And remember to pass the House unanimously.
Excellent.
Take care. Have a great day.
Thanks. You too. I'll see you over in Judiciary in a couple hours here.
Oh, well, hopefully my colleagues will be as nice to you as Senator West was to me.
I wouldn't count on it, but we'll see. All right. With that, that'll end the hearing for House Bill 892. We'll now move on to Delegate Edelson. He just left out, so. Okay, of course. All right. We'll Delegate Charkoudian, and then Delegate Attar. Do you have a panel, don't you? Or do you not?
Bill, there's one person because she was told there's opposition, so she's nearby.
Okay, great. So we're going to do Delegate Charkoudian first, then we'll come back. If you could come to the, we would just do it at the,
Let me do this.
Yep.
Okay.
Thank you. Sorry.
Thank you, Mr. Chair. Members of the committee, for the record, Delegate Lori Charcudian, asking for a favorable report on House Bill 413, Montgomery County Speed Camera Notice Adjustment. So this is a pretty simple bill. It's a county bill passed out of the House delegation and the House. What this bill does is it basically changes the notice. When speed cameras originally were put into effect in Montgomery County, the requirement was that the notice be provided in a newspaper of county circulation. At the time, there was the Gazette and a number of other local papers. And so that was possible, and people actually used those papers to get their information about these kinds of things. Now, the only paper that serves the entire county is the Washington Post. And so that's a very expensive place to put the notice, and it's also a place that nobody sees it. So both from the perspective of what is it that's actually going to allow folks to track whether or not a speed camera is being proposed for a particular area, and also from the perspective of the cost, we're asking that we remove that requirement. Specifically at a time, I think everybody here is aware that all of our transportation budgets are tight, and the idea of spending money to comply with a notice requirement that isn't accomplishing real notice doesn't seem like a good use of our transportation budget. And so for that, I ask for a favorable report.
Excellent. Thank you very much, Delegate Charcudian. Questions from the committee? All right, seeing none. Thank you very much.
Thank you.
All right, see you soon. All right, with that, then we'll move on to Delegate Attar, and then we'll go to Delegate Love, and then I think is Delegate Lehman. Delegate Holmes right in front too. There, so we'll go Attar.
I'm waiting on one person.
Okay, Attar, Love, Lehman, Holmes. All right.
Thank you, Mr. Chair. I have two bills today. Can I begin with House Bill 1329? Thank you. Thank you, Mr. Chair and members. For the record, I'm Delegate Dahlia Attar here presenting House Bill 1329. This bill passed the House of Delegates unanimously. And what it does is currently, if you're on home detention serving a term of incarceration, so it's after you're sentenced, through the DOC, you get diminution credits. I came to find out a couple months ago, it was through a client of mine who was placed on home detention via placed on incarceration via home detention through a private home detention company, that you do not get those diminution credits. I called the company and I asked why, and the manager told me, well, the math is too complicated. And so this bill simply fixes that. And if you're placed on home detention, serving a term of incarceration, regardless if it's a company that's making money the longer you're on it, or the company that does not make money, this bill just allows you to get that diminution credit. So I ask for a favorable report.
Excellent. Thank you very much. Questions? Was really bizarre. So is it a communication thing if the private companies don't?
So they
have nothing to do with each other. I mean, yeah.
They have nothing to do with each other. And they said, well, most people are pre-sentencing. I said, well, I've seen the last couple of years, many people are placed on home detention through the private home detention company post-sentencing. And I will say that most people that I've spoken with have said, well, it's not really an issue because most people are pre-trial. That's fine. But what about the people that are post-trial?
Thank you for the bill.
Sure.
Senator Carter, go ahead.
I want to thank you for the bill. I think it's a really important bill, and I too have had clients that are post-sentence home detention, and I did not realize they weren't getting DIM credits. So great bill.
Thank you. And if I can just for the record say this will not affect my client. We went to court and resolved that. So it will not. Full disclosure.
There you go. All right. Well, thanks. If there are no further questions for House Bill 1329, we'll move on to your next bill.
Thank you, Mr. Chair. For the record, I'm Delegate Dahlia Attar here presenting House Bill 763, Commission on Hate Crime Response and Prevention. Last year, this body passed a bill that would create this commission, and it listed multiple agencies to be included in the commission. This is something we generally do not do. Naming organizations on this commission then led to a significant hurdle this year. One named organization was not acting in good faith, and the White House even disavowed this group. The Attorney General Brown then suspended this member of the commission, and then he believed that he reinstated the member because he believed he did not have the authority to suspend them based off of the way the commission was drafted. We therefore passed House Bill 763 in the House, which changed the membership from listing organizations to requiring 15 individuals to be selected as members by the Attorney General. This would solve the problem we are facing now with this organization being on the commission, and it would ensure we do not run into any similar problems with any other future organization. So I ask for a favorable report.
Excellent. Thank you very much. Questions from the committee. We have Senator Sidnor, then Senator West, and then I have a question at the end, but go ahead. Senator Sidnor.
Thank you. I just wanted to push back a little bit about the organizations and naming organizations. We do that all the time. The question I have is this modification, just kind of giving the Attorney General carte blanche to put 15 individuals on. How do we know? And the thing that I appreciated about last year's legislation is you kind of picked, individual organizations that touched on different communities that might be affected by hate crimes were cited or sat on this commission. Under this, we have no idea who he's going to appoint. How do you respond to that?
So that is correct, but the bill does specifically state that the 15 individuals, one would be a public defender and then 15 additional individuals who are members or advocates on behalf of a protected class under the state hate crimes law that's set forth in Title 10. So that still does give him a huge amount of discretion. But I have faith in our Attorney General that he'll ensure that all those at risk of hate crimes are represented.
What if, the Senate has an executive nominations process? Would you be amenable to us being engaged so that we know who's being placed on this board?
Absolutely.
Okay,
Absolutely. Thank you.
thank you.
Thank you, Mr. Chair. So this year, when we've been doing work groups or commissions or study groups, we've added language to each of the bills forming these organizations that gives the appointing person, for example, in this case, you've got a representative of the Maryland Chiefs of Police Association. So our bill would enable the Maryland Chiefs of Police organization to remove the representative that they had appointed and appoint someone else in their place. And also it requires the organizations to establish some kind of bylaws or rules of ethical procedure so that if someone misbehaves, it comes to people's attention. Our feeling is that that would be the way to solve this kind of a problem in the future. I noticed this bill does not have that language.
So
Why not?
So I would say that we did actually pass a bill in the House of Delegates. I'm not sure when it will be in front of here, and I'm sorry, I don't have the bill number in front of me. That would resolve that for all commissions in general, and it sets a policy in place for all commissions. But I have no objection if you want that added specifically in this bill as well. But we did pass that bill in the House of Delegates already.
Okay, great. Thank you.
Thank you.
Yes, so that was my question. I was made aware of that yesterday about this bill that's coming. I don't know if it comes to our committee, but because we've been tagging this language onto every task force we passed. And so I wonder what type of conflict that would create if two were to go into law. So we'll figure that out, but thank you very much. All right. Thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for House Bill 763. We'll now go on to two witnesses.
Sarah McKee.
Sorry, Delegate Attar, you had a panel?
Sarah Mirsky is here from the Baltimore Jewish Council, but she was told that there was someone in opposition, so that's why she came to testify.
Right.
If there's no one in opposition, she can, or it's up to your.
Is the Reverend Kobe Little here? Is he here? I haven't seen him, so he signed up in opposition, but is not here, so.
Okay, well, thank you.
Excellent. So with that, that'll end the hearing for House Bill 763. And now move on to Delegate Love.
Thank you, Mr. Chair. And speaking of witnesses, I do have two people testifying virtually. One is a witness to testify, and one is just there as an expert witness if anyone has any technical questions. So with that, Mr. Chair, good afternoon, members of JPR. Nice to see you. For the record, Delegate Sarah Love here to present HB 1001, Automated Enforcement Programs Privacy Provisions. So as you all are well aware, right now in Maryland, we allow a number of automated enforcement programs. We have school bus cameras, we have red light cameras, we have speed cameras in school zones, in work zones, in residential areas, on certain roads in certain places. We have vehicle height monitoring cameras, and we have railroad grade crossing cameras. So that's the existing cameras that we have. Just this session, we have had bills to add Baltimore County to the residential camera program, to expand the work zone program, to enable a jurisdiction to add cameras on high-risk roads, to enable a jurisdiction to add cameras on every traffic sign, to enable 3 jurisdictions to use noise cameras, to enable cameras on all buses to monitor dedicated bus lanes, bike lanes, all bus stops, all curb cutouts, double parking, and all no parking signs. That's a lot of automated enforcement and a lot of data that is being collected. However, there are no statewide standards on this data. So that's what HB 1001 does. It creates statewide standards for the retention, destruction, access, and use of all of this automated enforcement data. It says, in addition, it says that no biometric technology can be used, so no facial recognition can be used on this technology. It does allow a carve out, and you'll hear about this in a minute from opposition. It allows law enforcement to access this data with a subpoena, court order, or warrant, but in exigent circumstances, they do not need to get a subpoena, court order, or warrant. That is current Fourth Amendment law. We didn't have to add it in there, but I put it in there for them just to be clear. So this is what's done in Montgomery County. The first county to use speed cameras, the county that has the most speed cameras. When law enforcement, one of the detectives believes that automated enforcement data would be helpful, they get a subpoena to access that data. It takes a day. If it's exigent circumstances, they can get it right away. So I want to be clear that the language that we worked on is what's done in the largest county that uses this data. In addition, I met early on with the chiefs and sheriffs, and a sheriff that was representing the chiefs and sheriff looked at the language and said, yes, this is great. Unfortunately, they came back later and they say that, I'll be honest, I don't really understand their opposition, but they oppose the bill. So for those reasons, I respectfully request a favorable report, and I'm happy to answer any questions that you may have.
Sure. We can hear from the rest of your panel and then open it up for questions if you like.
Great.
We do that. So let us hear from Mr. Weiner. You're up.
All right, can you hear me?
We can. Welcome.
Thank you. Chair Smith and committee members, my name is Jake Weiner. I'm a lawyer at the Electronic Privacy Information Center in Washington, D.C., where I study the ways that surveillance technologies can make us all less safe if we let them. I urge you today to advance HB 1001. It's a sensible set of privacy protections for automated traffic cameras. This bill is not going to be the first of its kind in the country, but it will be the most comprehensive. So you have a chance to lead here and lead the nation. And at the core of this bill is a simple premise. Traffic cameras should be used for public safety, not for mass surveillance. By imposing a warrant requirement, this bill just aligns police procedures for automated traffic enforcement with the way the police already handle most searches. When an officer wants to search a house, or when they want to unlock a cell phone that the police already have in their possession, they have to get a warrant. And warrants are the basic requirement that police must meet under the Fourth Amendment of the Constitution. All they really do is ensure that police have a good reason to look into your business. So there's nothing radical about a warrant requirement, and we know from hundreds of years of history that warrants are not an impediment to police work. Just like we as drivers need to obey the speed limit, warrants are the rules of the road for police officers. This bill will protect Marylanders from two very serious harms. First, and very importantly, the bill bans the sale or transfer of location data so it doesn't end up in the hands of unreliable third parties or bad actors. Location data can be extraordinarily sensitive because a traffic camera doesn't just record violations, it's also recording your location at a given time. And that means, for example, that a camera placed by a Planned Parenthood might tell you when someone's getting an abortion. Without protections, data from these systems could end up in the hands of police in other states that criminalize abortion, be sold to advertisers who might profit off of your personal medical history, or end up on the dark web. I really urge you to pass this bill.
Excellent. Thank you very much, Mr. Weiner. So that'll conclude the testimony for the proponents of the bill. We'll now open it up to questions from the committee. Senator Sidnor, then Senator West.
Good afternoon. Two questions for you. On page 3, lines 28 through 31, the definition for facial recognition technology, is that was that definition mimicked from one of our facial recognition bill that we currently are looking at this session, or is it its own? Does it stand alone?
That is a good question. I have not compared it. That's just what drafting put
Well,
in,
look, no
so
problem, no problem.
I don't know. Sorry.
The second question that I had, and I'm asking, this is certainly friendly questions because I wish I would have thought of this. On page 5, lines 20 through 22, when it talks about the destruction of the data, it says that some may be disaggregated for analysis purposes in a manner that does not identify any individual. I'm wondering, because one of the things that Baltimore County did do when we attempted, the Baltimore County bill passed out of the Senate. It's my understanding that it's going to die in your committee because it doesn't meet whatever state parameters that we have on community cameras. We had put in provisions because we wanted to know who was being captured here. It would be disaggregated, but we wanted to know if we were having certain racial impacts. If the information is de-identified, I'm wondering, would that hamper any efforts to ensure the equity in how these cameras are being used?
Okay, I will admit I haven't read the bill. I believe it's Senator West's bill. I know it's coming over to our committee. I think
No,
it's also.
he has a different.
He has a different bill.
695 cameras. It is it's supported by our delegation, as was the other one.
Okay, my mistake. So I'm a little unclear because speed cameras generally don't get the driver.
Right, but
it's some of the other cameras that do.
Right, what we put in was I think census blocks as a substitute, because generally by census blocks you don't generally know who's the people who live in those communities, to give you a better understanding.
So when you say census blocks, do you mean how many people are caught at a camera in that particular census block, or do you mean people caught on a different camera, drivers that are from that census block?
From the census block.
So you'd have to run down the tag and know if they were from that census block?
I believe that's how it's to operate.
So
that's just one example. What I'm trying to understand is, again, if let's say we want to ensure that there's some equity in how these cameras are being placed and trying to have an understanding of who's being captured, would this be a prohibition to trying to understand that?
I don't think so. I think where they're being placed has nothing to do with this bill. So that's one issue.
Right.
And who is violating? It's just a straight numbers issue. So if you are 12 or over, you're going to be caught by that camera. I think but
there's some individual behind certain these cameras. There's some connection that the way that I read this language, we would never really know who it is that's being caught in this on these systems.
I'm happy to take a look at the language that you're talking about, because I'm sorry.
Because again, I heard about this and I'm glad I like what you're trying to do. But I'm just wondering also, but for those purposes, how we address that.
Sure.
Thank you.
I'm happy to take a look at that language and talk with you offline.
Thank you.
Sure.
Thank you, Mr. Chair. So I'm thinking of the situation that occurred some years ago where an assistant U.S. attorney was found murdered up in Pennsylvania. And there were images of him driving through the toll booth, as I recall, at where the JFK highway enters Delaware. And so they were tracking his whereabouts by looking at these cameras and seeing if they couldn't try to investigate what happened to him. So I'm looking at your bill and it says, except as provided paragraphs 2 and 3, an agency may not access or use a recorded image without a warrant, subpoena, or court order. And my understanding is warrants are generally only obtainable if you establish to the satisfaction of the judge that the person that you are trying to investigate is either a criminal or involved in criminal activity. Is there any way in which this bill, because of if we pass this bill, if a police agency is trying to engage in an investigation and wants to review all the data of someone who passed a certain location or was captured running a stop sign or running a red light or whatever, and went to court to get the warrant, the court might say, you don't qualify for the warrant for this. See what I'm saying?
So in any
Are warrants
warrant or
available
subpoena,
just for an investigatory work, or do you need to have something more specific and more incriminating in order to get the permission from the court to issue a warrant?
so anytime that law enforcement goes for a warrant, it is possible that a judge will say you don't satisfy the requirements. But what I can tell you is
so in this case, what are the requirements? Yes, that's what I'm getting down to. If I'm a policeman and or an investigator, I'm trying to find out what happened to that assistant U.S. attorney, and I wanted to take a look at all the data from that toll booth up in Delaware. What would I have to establish to the satisfaction of the judge in order to get such a warrant?
So I can answer how it works in real time right now in Montgomery County. So a detective calls the person who's in charge and of the speed camera program and says, we are looking for someone who was driving a blue such and such.
Right.
And the person who was running the program has one of two options. One, they can say, go get a subpoena. And so then the detective comes back in an hour or a day with their subpoena. Or the person can do a scan and say, you know what? You want to go get a subpoena, which means there might be relevant information there. So they go get a subpoena, they have it, and they can review it.
Okay, well, subpoena presumes there's a court case because the subpoena would be issued under the authority of whatever court is on top of the subpoena. Let me give you another example. They're investigating a murder which occurred in a particular neighborhood. And near the neighborhood, there is a speed camera that captures information. It's just an investigation. The person who committed the murder might not have gone through the speed camera, but they might have. So the investigatory officer wants to get all the wants to take a look at the information recorded in that speed camera that evening, the evening the murder occurred. What hoops will the investigator, if this bill passes, what hoops will the investigator have to jump through in order to get the warrant or the subpoena or the court order? And is it possible that the investigator won't be able to get the warrant because the information doesn't rise to that level? See what I'm saying?
So they'd have to go through the same thing they would have to do if they wanted to do any other search. So it's the same thing. And
that?
Oftentimes our law enforcement, Senator, they want to, there's a murderer in a certain neighborhood. They'd want to go through every house, but they can't. They have to get a warrant. They have to know what they're looking for and have reasons that they can articulate to the judge. That is just the foundation of our system. And if I may, Senator, I'm sorry.
Sure. Yeah, I'm sorry.
I think the other problem that we have here is that these cameras, they are traffic cameras. They are not surveillance cameras. And if law enforcement wants to use them for surveillance, then they need to go out and say, hey, everybody, these cameras, they're surveillance cameras. They're not speed cameras. They're not red light cameras. They're surveillance cameras. And that's not what we have right now.
Okay, well, if I could push back a little bit, to go into somebody's house, you have to get a warrant. There's no question about that under the U.S. Constitution. But these are people driving on the public roads. There's some presumption of privacy when you're driving your car on the public roads. So it's a different situation. And it frankly ought to be a different standard to get a warrant. If we need warrants under that situation, there ought to be a different standard for getting the warrant than the standard for getting the warrant to go into someone's house and search their house. Don't you agree with that?
So if I may, Mr. Chair, if my technical expert is on, Chris Tippery, if he could explain how it's done in Montgomery County, I think that might address the senator's question.
Sure, yes. Was he also going to provide testimony?
No, he's just here to answer questions.
Go ahead and pose your question to Mr. Tippery. Mr. Tippery, can you hear us?
Yes, I can.
All right, excellent. Senator West has a question for you.
Have you heard our colloquy up until this point?
Yes. I believe there's also a provision in the bill for exigent circumstances. So
would that assuming a murder occurred 3 days ago up in a particular neighborhood, would that constitute exigent circumstances sufficient to authorize the police to access speed camera footage from 3 days earlier on the roads near the house?
The question would be is if the violation occurred, then it does take a reasonable amount of time for the citation to be processed. So it has to meet the several parameters when it has to actually have a speed violation. So the data would be there for us. So if a subpoena were to be issued, we could get that data as long as the violation occurred.
So here's the deal. If this bill is passed, I don't want police engaged in lawful investigations of murders or things like that to be impeded in their investigation because they're not permitted to take a look at any video information that's in the possession of lawful authorities, because it doesn't rise. The grounds for getting that information doesn't rise high enough to allow a court to issue a warrant or a court order. You see my concern?
Yes, I do.
Okay. Do you think my concern is well founded or not?
It depends on the circumstance. You know, again, if a violation occurred, then we would have that image for a long period of time, because that citation needs to be processed and then adjudicated. So the data would be there for quite some time.
Unless it's been deleted. And there is a section later in the bill that says the agency shall immediately remove from its records and destroy any recorded image captured under a program that doesn't constitute evidence of a violation. I assume that's a violation of speeding in this case, or constitutes evidence of a violation once all the avenues of adjudication have been exhausted. So I don't know what immediately means, but you understand my concern here. If someone's,
yes,
if you're trying to investigate a murder which occurred and there's a speed camera nearby, if I were the investigator working for the police department, I would want to take a look at the images recorded by that speed camera to see whether or not I can find some suspect who was on the road close to the house where the murder occurred at about the time that the murder occurred.
Senator, if I could jump in, Mr. Tippery is just here as a technical expert.
Okay.
So I don't think he can go directly to your question.
I'm sorry. Okay.
And I do understand your question, Senator. I think the answer is Montgomery County has been doing this and they have not been impeded in their law enforcement investigations. You have real life example for many, many years, and they have not had problems solving crimes and doing law enforcement.
Is that right, Mr. Trippery? There's never been a situation in Montgomery County where the people investigating a crime and wanting to take a look at this sort of footage have been unable to look at the footage because of the provisions in the bill we're asked to pass?
No, we actually have subpoenas on file that have been issued in the past.
Subpoenas.
They get subpoenas. The way in Montgomery County, it's a subpoena.
Okay, well, let me, since you're the technical expert, how do you get subpoenas where there's no case that's been opened?
It's for an investigatory search. Or
You can just go to a court. You can go to a court and get a subpoena for an investigatory search in Montgomery County. Even though there's no active case, you can still go to the court, and in aid of an investigation, you can get a subpoena.
Mm-hmm. Yes.
Okay, thanks.
And a warrant. Yeah. Further questions from the committee? Senator Folden's got a couple questions. All right.
I almost got out just in time.
All right. With that, that'll conclude the testimony for the proponents of the bill. We have one person signed up in opposition. Ms. Mansfield, welcome.
Great. Thank you, Mr. Chair. Members of the committee, Andrea Mansfield with Manus Canning and Associates, representing the police chiefs and the sheriffs. And sorry, actually, Chief Dave Morris was planning to be here today. I know he's probably a little more colorful than I am, but he is sick, so you're stuck with me. But anyway, I'm here in opposition to House Bill 1001. Do want to thank the sponsor. We did meet with her, and yes, she did amend the bill to include the exigent circumstances language in the legislation. and we are appreciative of that. However, with further conversations with my client, they still had some concerns. And actually in Senator West, really their concerns were kind of getting at the same line of questioning that you just had. Even though the language, the exigent circumstances language is in the bill, law enforcement can find themselves in other circumstances that maybe it doesn't meet that criteria. And because they need to get the subpoena, the court order, or the warrant, it would impede them from doing the investigation and getting that information that they really need to solve those crimes. And I know Montgomery County does have this process in place. However, Montgomery County is the only jurisdiction that does have this process. And it's my understanding that they put the process in place because of really working with the county council when they were enacting their enforcement camera legislation and the number of cameras they were putting in place, they felt that they needed some sort of a checks and balance system. So the county council was actually involved in putting that process in place with the administration at that time. But they're the only jurisdiction. And I guess I would say this is maybe a situation where what works for one jurisdiction maybe doesn't work for every jurisdiction across the state. I know in other counties, they feel strongly that their citizens would not want them to have the additional hurdles to go through if there is a crime being committed or there's an investigation that needs to take place. Also, just really quickly, I would mention the language in the bill dealing with the immediate destruction of the data. That could also be problematic if this data is being used for an investigative purpose. I think that language, we maybe need to look at it a little bit closer if you do want to have more direct conversations about the bill, just to ensure it's not limited to auto enforcement only. And if there is an investigation, that data can also be maintained for those purposes. Thank you.
Thank you, Mr. Chair. So just thinking out of the box here, if we were to add language to this that's along the lines of in the event that there is an active police investigation of either a crime or criminal activity, that fact will suffice to authorize the court to grant a warrant or a court order or obtain a subpoena. Would that satisfy your concern? In that regard?
Yeah, I would need to talk I would need to talk to my client specifically about that language and adding the language, and I can do that.
And we could add similar language down in the destruction of recorded images that said that they would that one ground, but that the destruction would not occur if there's an ongoing investigation that the agency's been informed of until the investigation is completed, something like that.
Okay, I will
thanks.
them and get back to you. Thank you.
Thanks so much. I just don't share my colleague's concern or agree that this would be a hindrance to an investigation. You know, outside of this bill that's proposed, the current law is very clear about the circumstances under which a subpoena can be issued if there's an investigatory reason to get it. The law is very clear about when a warrant can be issued. That's why no matter what a police might suspect of someone, we don't say they can just run up in somebody's house without a warrant. We say get a warrant unless there's exigency. So I think that it's already clear in the law. And my concern is that the concern of the chiefs and sheriffs is unwarranted, uncalled for, and could possibly be just an impediment to getting this bill. So I guess the question is, what do you feel is missing from current law that already makes it clear what the standard is for being able to get a subpoena or a warrant?
And I believe in this situation, they believe that having the additional requirements there is going to be an impediment. If it is, something happens at a school and there's a school camera and maybe an individual, God forbid, something, there's an altercation or something happens and the individual speeds away in a vehicle. Waiting to get that additional information, if it's a day, that day could actually be a hindrance. Somebody could travel, out of the state in a day, or different things, or go into hiding or something. So I think really it's the immediacy of wanting to get, if they see the situation, they're doing their investigation, they believe that something could have been caught on that camera. They want to be able to go get that information immediately so they can find the individual that committed whatever the crime or circumstance was. So they want to do that.
Probable cause of the exigency, the law is already clear that they can do it. If there's not, then they can't. They got to get a warrant. So,
and I guess
if you could just help us understand why the exigency exception is not enough. Functionally, how does that work?
Yeah, I mean, I think the exigent circumstances, I mean, I think in some cases it is very broad. I didn't bring the exact definition with me on the language that was being discussed in Delegate Love's subcommittee, but I think it could be left to interpretation. So if it's, maybe it's a string of, maybe there's like car break-ins in a neighborhood, and I'll use my neighborhood as an example, Ponte Orchard. There's various little sections with townhomes and apartments and so forth and single family homes. If there were car break-ins in various sections of that neighborhood, you know, and we know that the car went through that speed, that the school camera situation, you know, would that meet the definition of exigent if it's not like serious public injury or there's, you know, it's like not raising itself to quite that level of public safety, but there was a series of car break-ins that where this information could be helpful.
Thank you, Mr. Chair. So I apologize for being late here. Now I really do wish I had pushed my button earlier. So on the exigency circumstances, doesn't that allow for an interpretive analysis or interpretive measures to be argued in court, which could deem potentially this not admissible?
Yes,
if depending on who the judge is, because they're going to argue exigency and the judge is going to be like, well, you know, maybe it was, maybe. And each individual case is alone. My bigger question is there any expectation of privacy when you're driving down the road and you are caught on one of these video cameras or automated speed devices?
Actually, my understanding, there's not. From talking with my client.
Is there anybody else in the state other than municipal or state agencies that run these camera systems? So what I'm saying is, my point is, there are other government agencies that run these? There's no one else,
Not
right?
in the state, no.
So these are our partners in the community who we should be able to go to if law enforcement is going to do an investigation that they would normally not even need to get a warrant. Because does the same apply if we're looking at someone goes in and the Department of Social Services and they're caught on video ransacking the place? Are they not allowed to use that right away to go and chase the person?
Yes, they would
To
be.
identify the person? And I guess the last thing is there any violation of the two-party consent rule? Do these record any audio?
No, they do
They
not.
don't. So there's really no reason for any of this because there's no expectation of privacy. There's no recording other than video. And this would assist, especially in some circumstances where we don't want to have to argue the exigency, but where there may be someone that was taken against their will or the like, that they shouldn't have to make that argument. They should be able to have this information available and be able to utilize the information.
Yes.
All right, thank you.
And thank you. And also just to add to what you were saying, also need to point out, I know this is we talked to the House sponsor about this in terms of who is the owner of the data, but in some of I know in my client situation, sometimes it is the law enforcement agency that owns the data, or maybe it's the county that owns the data.
Correct.
So they could then be
That's
subpoenaing.
you could be
themselves
subpoenaing yourself.
that
That was
situation.
what my point was, is
And-
that it's
yeah.
the same government agency.
Yes.
Okay, thank you.
Thank you.
No, it was good. I was listening. It was good. 2 years is good. No, thank you very much. We're going to follow up with Mr. Tippery because, you know, the distinction between a warrant and a subpoena different. And then it sounds like Montgomery County is getting these subpoenas but they're not functioning like warrant. Yeah, I know. That's what I'm saying. I understand. So I do want to understand more about how that's working. So we'll probably follow up with Mr. Tippery before we take action on the bill. All right. So with that, that will conclude the testimony and the hearing for House Bill 1001. Thank you, Delegate Love. We'll now move on to Delegate Edelson's here, and then we've got Delegate Holmes, and then I know we've got everyone here. We've had an order here. Lehman is next, and then we will go. I see Lopez here. Weibel's back. I know Weibel Kerr is here as well. And so is Rosenberg. All right. And Pippi right in front. But Edelson, go ahead. Welcome. I see it. Holmes is over there. Gotcha.
Thank you, Mr. Chair. Thank you for the courtesy as well. Thank you, members of the committee. Great to be with you. For the record, Delegate Mark Edelson, representing District 46, Baltimore City, and I'm here on HB 38. The idea for this bill is to use the excellent idea that came out of Montgomery County and make more affordable housing near our transit. So the focus here, it's like I said, it's a local bill for Baltimore City. The focus is that we would draw a 1/4-mile radius around all of our current and future major transit stations. And in that area, remove the requirement to mandate parking being built in any new residential or building conversion. The focus is on MARC stations, light rail stations, the future Red Line and Metro stations. The bill was heard in the Baltimore City Senate delegation on Friday. I believe it's up for a vote this Friday. I'm happy to take any questions, but that's really all there is to it, Mr. Chair.
I may have missed something. Did the local delegate, the Baltimore City delegation unanimously approve this?
In the House, yes, it hasn't been voted on in the Senate.
I was gonna say in the Senate, I don't think it's been presented to us.
Yeah, sorry, I moved a little quickly on that. The Senate heard it on last Friday. My understanding is they're voting on it this Friday.
The Senate delegation?
Yeah, the city Senate delegation.
Okay,
correct.
I'm a member of the Senate. I haven't heard about such a meeting, so.
Baltimore City Senate.
I'm sorry, of course. Yeah, exactly, you're right. Okay, thanks.
No problem.
All right, further questions for the delegate? All right, thank you very much. Good to see you.
You too. Thank you, Mr. Chair.
Excellent. All right, now we'll move on to Delegate Holmes. Yes, of course. And then we're Delegate Hutchinson, you're gonna be next, okay?
Thank you, Mr. Chair and members of the esteemed committee. I am here in reference to HB 793. For the record, my name is Delegate Marvin Holmes, representing the 23rd District. What before you today is a bill that is requiring training for board members. And one of the reasons why I'm here requesting that you pass this legislation is because I am attempting to reduce the time frame that I come here in front of you every year. I know all of you would appreciate that. If board members were trained, we know that they would be more appreciative of the new laws that occur every year. Every year, every member of this committee receives all of the new laws that have been passed every year. I make sure every one of you get a copy of that book every year. This bill before you now has been requested by multiple jurisdictions throughout the state. So much so that Charles County just this year has put in a bill, the exact same language that you see here. And what I am attempting to do is not to have 24 different types of board member training, but to have staff member training. Charles County is fearful that the statewide bill will not pass, which is why they moved forward with theirs. You're going to hear some testimony in reference to time, commitments of the board members and cost. What we are finding out is that when board members are trained, they are more likely to serve on the board longer. They are more excited about serving on the board, and they do a better job at it because there are so many things relevant to being a board member that just does not come by being involved with other additional board members. I want to also emphasize the point about cost and time. Currently there are 2 CCOCs in the state. CCOC stands for Commission for Common Ownership Communities. There are 2 in the state. In order to be on the CCOC, you must be appointed, nominated by the county executive and approved by the county council. And I am a member of both Montgomery County and Prince George's County CCOC. Each of them offer board member training for free. So that eliminates the cost concern. One of the things that is in the bill that you'll see, it outlines all of the criteria that has been looked at by the national organizations in terms of what board members should be trained on, and they are listed in the bill as well. And as I indicated earlier, you're going to probably going to hear testimony that's not needed because the board members have already been together for many years and they know what they're doing. It's interesting in that because there's no state agency in charge of common ownership communities in Maryland, there's no state agency in charge of state agency in the state of Maryland. I said it twice. And because of that, my phone rings off of the hook and I'm being asked repeatedly to go all across the state to train board members. We just got off of a board member training this past week. And because they had asked me to attend to advise them on certain processes relevant to the new laws. If this bill were in place, that would take the place of me solely going across the state until we get some state agency that's going to take responsibility for this. With that, Mr. Chair, that is the bill in a nutshell. And I will take questions or allow the other person that I brought up here to testify. That is the bill in a nutshell. Board member is absolutely necessary, ladies and gentlemen.
Thank you and good afternoon, Chairman and members of this prestigious committee. For the record, my name is Kim Ross and I'm the president of the Franklin Point at Dearborn Homeowners Association in Baltimore County. And I am here today to give my proud support of HB 793. I believe in it and I think that Maryland communities across the state really need this bill. Common ownership communities have their own governing body. They have their own set of rules and the buck really does stop with the board of directors. So they have a lot of authority and their actions and decisions significantly impact the quality of life for hundreds of thousands of Maryland residents. In fact, when a homeowner decides to join an HOA, condo, co-op, association board, they then become leaders of a nonprofit corporation. Does it surprise you to know that these powerful individuals who lead corporations are not required to have any training, no specialized certification, or any credential to do so? Board members are expected to enforce dozens of pages of governing documents. As an HOA president, I can tell you that board members do struggle to understand their governing document legalese. They do sometimes get it wrong. Many boards rely on their property management team, their property manager, to advise and consult when there are questions or concerns. But those individuals are also not required to be credentialed or licensed. As the delegate says often, they only need to have a business card to serve in that position. I personally have had to hire a law firm outside of the law firm we use for collections. I've had to hire a different law firm to consult and help us interpret the legalese of our documents, which is an expense that could be reduced if board members are better trained. Training would help ensure that homeowners' rights are not being violated. That's happening every day, simply because board members do not have the education or the information that they need to properly support and govern those communities. You can do something about
Ms.
that.
Ross.
Don't let that happen on your watch.
Thank you very much, Ms. Ross. We'll now switch to the committee for questions. We got Senator Muse and then Senator McCain and Senator West.
Thank you, my good friend and delegate. Over 3 decades, we've been working together and we've been working together on these issues.
Yes.
When you're a member of the board, you have many of them have very large budgets. Is that correct?
Yes.
Many of them can also put liens against properties, home, right?
That is correct.
They can go to court, take people to court, and all of the kinds of legal things that you're talking about. Many of these persons are new at it, and they're making decisions based on maybe what the majority of the other board members will do. I know you said it, you'll hear the opposition say, well, they don't need it because they have been members and they are self-trained. I was always taught to consider the source. When I sit down and I got people in the room and I'm I'm going to follow them. I want to know what the source is. Who are they? Where's their training? So can you give any other good reason? Because when the opposition says that, I'm going to ask two things. One, why not? What harm does it? And how do you just paint with a broad brush and say every board is self-trained and that's sufficient when the power that they have over the lives of people, it can be devastating. What other reasons would there be for someone to say to you, after all these years you've been involved, why we don't need it? They don't need it.
Well, I think the main reason why those board members continue to say that they don't need it is because they don't know what they don't know.
Correct. Okay.
They simply do not understand the gap between what they're doing and the understanding of the law that they're supposed to be enforcing. They just don't know what they don't know.
Okay, it's a good bill. Thank you for
Thank you
bringing
very
it to
much.
us. Thank you, Mr. Chairman.
Good to see you, sir. Mr. President, Mr. Chair,
How are you?
Fire and Safety.
Wonderful. So, what current steps right now stops a board from offering an education of their board already?
What stops them from offering it?
Yeah,
They-
I mean,
a board-
if a board
boards-
decides they want to become more educated in the laws that we pass down there, does anything stop them from doing that right now?
The only thing that would prohibit them, nothing stops them, but the issue is who's going to train them? If they aren't trained, then how are they going to train someone else? As an example, I mentioned the two CCOCs in state of Maryland, Prince George's County and Montgomery County. Each of them offer training. The training for Montgomery County CCOC, as an example, is offered second Saturday and fourth Sunday of each month. Okay, and that's the offset Saturdays and Sundays is for religious reasons. Those trainings are all in a lot of times jam-packed with people coming to take because they recognize the value of it. Prince George's County training is also multiple registrants all the time. So the answer to your question is there's nothing prohibiting a board from training themselves, but the problem is they don't know what they're training themselves on. Like I indicated in the very beginning, this entire committee every year receives a book from me showing all of you the new laws that took place the previous year. Board members who aren't trained are not aware of the new laws at all.
The other testimony from the other person talked about that they had to hire a lawyer to help with some of their training. So are we saying that all these board members now need to be attorneys?
No, absolutely not. Absolutely not.
And
no.
And so, but what stops that to be the next step? We're talking about who's going to be the trainer. It would seem to me that the B&O or the board of directors insurance that a board would have to get, that
fiduciary insurance, yes, sir.
That would talk about some form of a training from an insurance standpoint to make sure that those members are knowledgeable. Is that not true?
No, that's not true. Fiduciary insurance for a board of directors only kicks in when the board of directors does something afoul of the bylaws. It does not require the fiduciary insurance does not require anyone to be trained. It only steps in when there's something that has taken place in absence of the bylaws. And what one of the issues is that most of the board of directors members have not read the bylaws. Have not read the bylaws. There are 4 or 5 different documents that govern common ownership communities. There's a CCNRs, covenants and restrictions. Underneath that are the bylaws. And then underneath that are the other documents. Most of the board of directors members have not read those documents. And specific training will teach you not only what to read, but how to interpret them as well.
It just seems to me that it would be inherent of anybody that would become a new board member, that they would either on their own, as the board of directors suggests that they would do training, or they would on their own read the bylaws of an organization that they're now becoming an administrator of the building. So you and I have a common thing with fire and EMS, and with the many volunteer companies out there, we seem to be putting all kinds of regulations, training, those type of things onto it. Could this become some kind of a slippery slope, that we're putting so much training onto these board of directors that they end up having to, and I go down this, then having to be a lawyer to actually interpret? You know, the good senator sitting to the left of me said, when I got on JPR, she said, "I assume you're an attorney." I said, "Well, no, I'm just a small businessman." And she said, with all due respect, she thinks everybody on JPR should be an attorney. Well, after 2 months, I kind of decided that not everybody should be an attorney on JPR. But that being the case, I'm not exactly sure that we're going to go down this slippery slope of so much credentials that it becomes now a profession, not a volunteer board.
Let me answer your specific question. And for those of you who don't know, I have been the chair of the Fire and Emergency Medical Services Coalition for about 7 or 8 years or so. And this year I decided to step down, and the good senator is now the new chair. And he's doing an excellent job. But to the example that you raised, you know that all of the members of the Fire and Emergency Services Coalition, and I'm addressing your specific question.
Yes.
All the voting members of the Fire and Emergency Medical Services Coalition do have training. They have been trained in their specific requirements of the job that they do. And the job that they do relevant to Fire and Emergency Medical Services Coalition is what takes place in those committee meetings every Monday at 2 o'clock. So they have been trained. They get training from the state and from each of their respective organizations. They get training. So they do get training. Board members on common ownership communities do not.
Is there any provision in your bill that maybe would exempt smaller boards, or exempt volunteer boards, or does this brush have to paint everybody?
There is nothing in the bill that exempts anyone, small or large. And let me give you an example why. There are a couple of small boards that I work with, particularly in Prince George's County. I'll give one example. It's 24 townhouses in Prince George's County. And they have not been able to understand how to adhere to their bylaws. So I'm frequently invited to their meetings to assist them to interpret it. And in the red books that all of you have received, all of the officers of that particular board have received those same red books. And I go through questions with them in that same book that I give to you all of you. So the answer is no. And in most cases, with common ownership communities, the smaller they are, the worse off they are. Not only in the training, but also in the reserve studies we talked about yesterday.
Well, thank you.
Yes,
Thank
sir.
you, sir.
Thank you, Mr. Chair. So I'm looking at the bill, which says that each member of the board or officer shall successfully complete a training curriculum developed by, and you list 5 organizations.
Yes, sir.
5 categories of organizations.
Yes, sir.
The first is a common ownership commission recognized by the state or local government. How many such common ownership commissions have been recognized by the state or local government?
Currently, there's just one.
Just one. So
Yeah,
this is
Maryland
a state,
Homeowners
this
Association.
is a
That's just one.
statewide bill.
There are.
Where's
Go ahead.
where's
I'm
that
sorry, go
one
ahead.
commission?
I'm sorry.
I'm sorry, this is a statewide bill. Where is that one commission located?
Prince George's County.
Prince George's, okay. On category 2, an organization approved to administer the training curriculum by a recognized common ownership commission. How many such organizations are
Now,
there?
that one, there is none yet. And that's because we are attempting to establish one with the Attorney General's office.
Okay, but at the moment, there are none. Number three, an institution accredited by the Middle States Commission on Higher Education.
That is correct. And currently,
how many institutions fall into that category?
there are currently none, but we are in the process right now of getting community colleges, Prince George's Community College and Anne Arundel County Community College want to offer these classes. That's why I put it in here now, because we're in the process of negotiating. They're in the process now of putting that program together.
All right, but at the moment, there are none. Four, a membership organization that offers nationally recognized certification credentials for community managers. How many such organizations are there in Maryland?
In Maryland,
Yeah.
this is national. There's the community. Sorry, you go ahead.
If we're talking about a Maryland condominium, it's hard to imagine that a Maryland condo is going to send its new board members to Milwaukee.
No, sir. No, sir. No, sir. No,
How
sir.
many,
No, sir.
how
No,
many
sir.
such organizations are in Maryland? Go ahead.
Two, there's a Community Association Institute that offers classes now, and there's also the National Association of Property Managers offers classes now. They are national organizations,
Right.
and they offer these classes.
And they offer them in Maryland.
It's online.
Online.
Maybe I misunderstood. The Montgomery County CCOC is online training. The Prince George's County CCOC is online training. Now I'm sorry, go ahead.
I see. No, I wasn't aware that online training was
Yes, sir.
included.
Online.
So this is not required in-person training. That could be online.
Online.
Okay. And then the last one, a county with coursework established by the County Common Ownership Commission. How many of those are there in Maryland?
None at the present time.
Okay.
But we are talking with organizations to establish it.
Okay, so there are at the moment, there are three such organizations in Maryland which have developed these curricula.
That is correct.
Okay.
And two nationally, but go ahead.
Okay, and I think you said earlier that all three of these organizations that are in Maryland offer this curricula free,
Yes, sir.
no charge.
That is correct.
Okay, last question for this part of my questioning, and that is, how long are these programs? Are we talking 2 hours, 5 hours,
good
20
question.
hours, 40
question.
hours?
Good question. Good question. When I do the training for the Montgomery County CCOC,
Right.
it is, like I said, the second Saturday of the month and the fourth Sunday of the month. And when I do the training there, it's from 9 o'clock to 1 o'clock on both of those days. You don't have to take both, just one. It's from 9 o'clock in the morning to 1 o'clock in
So
the
it's a
afternoon.
four-hour
I'm sorry, go
four-hour
ahead.
course.
Go ahead.
It's a 4-hour course.
Yes, sir. The Prince George's County, Prince George's County class is 3 hours.
Okay. All right. I'm sorry. Somebody said something. Okay, so it's either 3 hours or 4 hours, and it's free, and it's online.
Yes, sir.
Okay, that makes it a little easier. So let me go to the other thing I want to talk about. A couple of weeks ago, we had a bill or an amendment to a bill on the floor of the Senate to require various Episcopal churches to adopt Robert's Rules of Order. And we voted that down. And I sort of led the effort. I was the floor leader. I didn't accept the amendment as a friendly amendment, and we voted it down. And my rationale was, I don't want to get too deeply in the weeds of requiring organizations in Maryland to do stuff. It seems to me they ought to be able to make their own decisions what they're going to do. So we have corporations in Maryland which have boards of directors and officers. We have limited partnerships. We have general partnerships. We have limited liability companies. You can go down the list. Business trusts. There are lots of organizations in Maryland. We don't, to my knowledge, we don't require any of these other organizations to require their directors and their officers to take this sort of training. If this bill gets passed, is the next step to require all those other organizations in Maryland to require their officers and their boards of directors to get similar training?
I can't answer that because all of you know I'm basically a one-trick pony. I am chair of housing and real property, and that's the lane that I stay in.
Right.
And the reason why I stay in that lane is because I know that subject matter very well. I also know that persons need to be trained because they keep asking me to come train them. I also get a note here that says Prince George's County also offers a self-paced online course.
Okay. All right. I think you've answered, you know where I'm coming from. I think you've answered my questions and I really appreciate your answers. Thank you very much.
Sure. I'll be looking for a green button on that one.
Thank you, Mr. Chair. I'll be quick. I think my Senator West kind of covered this, but I just want to be sure, where else in the law, is there anywhere else in the law that you can think of that Maryland legislative, our body has taken it upon themselves to legislate a training that they have to go through as volunteers?
I don't know. And let me tell you why I am looking at this particular piece of legislation in this particular.
No, I understand why you're doing it. I'm just asking anywhere else in the law, anywhere else.
I don't know.
In Maryland that there's a legislative action, a call that I see a lot of people in this opposition from the one specific group. And I'm going to guess that there probably is Kings Court Townhouse Association. Is that in,
oh yes, they're right here.
Is that in your,
as a matter of fact, not to interrupt you, but they called upon me to do training for them.
Okay, but that's their right. That's their job. That's their right. But to mandate it is different because then you're limiting the pool.
I understand.
And people are already busy, but they want to do good for their housing communities. And you know, I find this very much again a governmental overreach where we're going to mandate and require legislatively somebody take training to be a good steward of their own community.
I understand understand where you're coming from entirely.
Thank you, sir.
Except that the common ownership community real article is a state law.
Okay, but it doesn't tell them to. It just says that they have to have a common ownership community board. It doesn't say that, you know, that they've got to go through training.
You are correct. That's why the bill's in front of you.
It's always good to see you, Delegate Holmes.
Yes, sir.
There are no parallels here, and I'm not speaking for or against the bill, but police accountability boards are one thing that comes to mind. Because those are citizen volunteers. We do MPTSC, they're required to go through 48 hours of training or something, but they're paid volunteers.
And it's government.
And it is a government entity.
But you stop becoming a paid volunteer when you're paid.
So you can get reimbursed, not salary.
We didn't provide for it in the statute, actually.
We didn't. The local jurisdictions have done that. You're not going to get a salary, you get reimbursed. All right. Well, thank you very much. Thank you.
Thank you all. I appreciate it.
That'll
Thank you.
conclude the testimony for the proponents of the bill. And I'll switch to the opposition panel and we'll hear from Ms. Socha. Come on up.
Hope you will speak up for me too, because my ears are just as plugged as my voice. So I can't hear. I was really trying to hear the entire conversation, having a hard time. So my name is Sonia Socha, and I'm the Vice President and Treasurer of Kings Court Townhouse Association in Baltimore County. And this is Nancy Costello, our President of the board. We've both been members of our community for about 40 years. It's one of the oldest ones in the state. We are opposed to 793 in its current format, and we do not favor any type of mandated training for our boards. We don't feel it's needed for HOAs or condos. Definitely training is needed, and it's extremely important for new board members who have had no experience serving on a board of any type. But you have to have as an option. And we know that because our new board members have said we'd like to get some board training. So what does that mean? Well, we could have a training manual that's prepared by the state that somebody could refer to, and it could have all the laws in it, and it could be updated every year. We could bring in somebody to do training. That becomes something that should be optional and should be individual to every one of the 7,000 HOAs and condos in the state, because one size doesn't fit all. And if you open the mandate situation, no 501c3 boards have mandates to train their board members. Also, this bill says that even the experienced board members also have to go to this training. we're not gonna have people wanting, the experienced board members are not gonna want to go to this training. And they may opt out serving on the board, and we need experienced people to do so. We need people on our board. It'll be a barrier for us to recruit good volunteers if we tell them they have to go to a training. It will be an encouragement to them if we can tell them they have the option to go to a training. So I ask you, please do not pass this bill in its current format. It's just not going to work the way it should. And for all the reasons you've already discussed. Nancy, do you have something to add?
We only had one person signed up on. We only have one person signed up on. I just have to adhere to the policy here. I don't want to get Senator, but if you have questions for her, then we can go ahead and ask. But if you'd like to ask a question, Senator West.
Are you, no?
You told me no.
Okay, all right.
Senator Fulton, go ahead.
To the wonderful lady seated at the table, did you have something to add? Since you came all the way down from Baltimore County?
I do, that the Community Association Institute that
Ma'am, I need you to stand up to the microphone, ma'am.
If standing's too laborious, you can sit and use the microphone if it's
If standing's difficult, you can use that. There you go.
I'd like to add that the Community Association Institute is currently working on a project for board training.
At the podium, ma'am. There you go. There you go. Sorry.
I'm an untrained board president, okay? So this is maybe what you're looking for. There is a Community Association Institute is currently working on a project for board training that is out there now. They're working on it, and I think I read that they were going to hopefully by October, November, have it going.
Yeah, I saw that.
Okay.
Yeah, at the end of this year, they're supposed to have something up and running.
At the end of this
Yep.
year. And I would also like to say that, of course, we would love to have you come and talk to our board and help us out. Okay, thank you.
All right, thank you, ladies.
I do have to say that if boards actually end up quitting because they don't want to go through a training, then what are you going to do? Because the state's the one that has to step in and run the HOA or the condo.
Well, we have a one-trick pony that'll run all of them. Thank you.
So, thank you. Thank you.
All right. Thank you all very much. With that, that'll conclude the hearing. We're gonna go to Delegate Hutchins with House Bill 593.
So good afternoon, Mr. Chair, members of the committee. For the record, my name is Delegate Tom Hutchinson. District 37B from the beautiful Eastern Shore. I'm here to present House Bill 593, Destroying Funerary Objects, Statute of Limitations with Amendments. This bill did not have a cross file. It passed unanimously out of the House 141 to nothing on a day that we actually had a full House. The purpose of this bill is to change, since destroying funerary objects is a misdemeanor. It currently has a 1-year statute of limitations. We're working to move this to a 3-year statute of limitations. And let me explain why. To my right is Tammy Doring. She lives over here in Anne Arundel County in District 30. And she brought the need for this bill to my attention. I've dedicated this bill to her great-grandfather, Wayland Truitt, who was born in 1891. He served in World War I, and he served in World War II as well, and was buried in the family cemetery in Dorchester County when he passed in 1972. He was laid to rest next to 21 marked graves of the Truitt and the Talls family. The family cemetery was located in the front of Miss Doring's mother's childhood home in Wingate in South Dorchester. After the home was no longer owned by the family members would still come down and took immense pride in the family cemetery, and every year they would visit the cemetery. The owner at the time of the home was very welcoming and accommodating to the family until he passed away. The house was subsequently sold to an individual interested in using the property as a hunting, rental, and Airbnb. And then unfortunately, COVID hit and the family missed their annual visits to Dorchester County. So finally, in 2021, after a period of at least 2 years from their prior visits, Miss Doring, along with her 80-year-old mother, traveled to the family cemetery. And it was then when the tragedy was discovered. When they pulled into the driveway, they actually thought they were pulled up to the wrong house. The graveyard was no longer there. Gone were the tombstones and the burial vaults of their loved ones. When they got out of the car, they discovered a pile of rubble at the gravesite, which consisted of broken vault covers and tombstones. Broken pieces of tombstones were placed around the front of the home to outline flower beds, and many broken or damaged tombstones were found in the neighboring marshes. The cemetery had been bulldozed and demolished, leaving open, exposed burial vaults. I've actually uploaded pictures of this in committee testimony. So the family confronted the new owner of the home, and he was very careful not to incriminate himself. Ms. Doring pursued assistance from local law enforcement and the state's attorney, but unfortunately, because current criminal law 10404 cemetery destroying funerary objects is a misdemeanor, there is a statute of limitation of 1 year. Because they could not determine when the actual destruction occurred based upon their last visit, and the time frame could not be determined, they were just told there was nothing that they can do. The statute of limitations had passed. So considering, as in this case, a family may not visit a gravesite annually, this bill simply extends the statute of limitations to 3 years for destroying funerary objects. We feel this is a reasonable amount of time for discovery, ample time to pursue legal action for those who have caused the damage. I do want to note that I received 2 amendments to this bill. They actually came from 2 different cemeteries in the state of Maryland. And I also received a number of calls and letters from others who've had this happen to them in the past with nothing to do. So it's just not a situation here with the Doring family. So passage of this bill may not help Ms. Doring and her family, but it will help other families who feel that the final resting places of their loved ones have been destroyed with nothing to do. So we very much ask for a favorable report on House Bill 593. And if you don't mind, I just have to ask Ms. Doring if she could make a closing comment to you.
First of all, I'd like to thank
Yeah, you're good.
Delegate Hutchinson for introducing this bill. And I would ask for favorable consideration. As he said, it won't help our family. But once we had discovered this had occurred and trying to get to the bottom of it, and we sort of narrowed down the timeline and sort of narrowed down who could have been responsible, there was still nothing we could do. So this will help anyone moving forward. Currently, we are seeking someone to help us finish excavating and put back the tombstones, including a 6-foot monument that was destroyed. So that's where we are now with the cooperation of the people that live there currently. So again, I would ask for you to vote favorably on this bill. I appreciate it. Thank you so much.
Thank you.
Thank you, Mr. Chair. This is appalling. The state of Maryland has an Office of Cemetery Oversight. Doesn't this organization control whether or not someone can take over a cemetery, empty all the graves, destroy all the monuments?
Ms. Doring, you would
I
like to ask
spoke to
that?
them. I spoke to them in trying to find out what we were to do before I contacted the state's attorney, and it came back to the statute of limitations. Well, you can't, oh, sorry. We were told, well, you don't have a witness of someone doing it, and you don't have someone coming forward to say they did it, and we could narrow it down to a window of time. But the answer was always the statute of limitations has been exceeded and there's nothing to do.
In order to tear up a cemetery and empty all the graves and destroy the monuments, one would think that this Office of Cemetery Oversight would require approval before that happens. And don't they require that the families of the people in this be notified?
Senator West, I'll address that. This property is in an area of Dorchester County that we call down below. I mean, it is down in South Dorchester on a private property. So it wasn't really a public cemetery. It was a plot in front of a home where the homeowner just took it on his own, who bought the house to make it into an Airbnb rental to just bulldoze it over and didn't think that anybody would notice or catch them.
Wow. Okay, thank you.
Senator Muse, did you have one? Okay, sorry, Senator Sidor.
Just a quick question, because we had a bill hearing earlier this year, just again, talking about people being able to visit, but ownership changing and then people, the new owners stopping others from coming in and visiting. What is right on private property? What has been your experience? Are you still able to?
Well, it was my understanding from the law that once the cemetery is established, the people that have loved ones there have the right to access it in perpetuity until there are no more relatives per se. And it was also my understanding that in order, as you had alluded to disturb these or move anything, every effort has to be made to contact a family member. And until those are exhausted, the person is not supposed to be able to touch anything there. But I just can't express to you, the shock doesn't even begin to address what we found. My mother had been going to see that cemetery every year. When we went, we didn't even have the wherewithal to take pictures at the very first time we went there, because we just wanted to get her, away from the situation. My sister and I subsequently went back and took pictures and documented, and I think you have some of that and in your file regarding that cemetery. But as Delegate Hutchinson said, it is a remote property. It's a very marshy area. Someone could have rented a small bulldozer and done this with no one seeing them.
Thank you very much.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you very much, Delegate Hutchinson, and thank you very much for your testimony today. I'm sorry about that. All right, so that'll conclude the hearing for House Bill 593. We'll now move on. Is Delegate Lehman here? She here? She was here earlier. I just want to.
I'm her chief of staff. She's down in finance and will be done in a few minutes if you'd like to wait for her.
Excellent. Then we'll go to, we got Delegate Pippy and then Delegate Kerr and then Cardin. Oh, sorry. Lopez and then Rosenberg. I'm doing it in order of people showed up. So people have been coming in and out. So I see the Majority Leader Moon back there as well. I've got him. All right.
Thank you, Mr. Chair. Committee members, Delegate Pippy, for the record here in support of HB 145. This bill deals with criminal law, deepfake representations, and revenge porn. So luckily for the committee, you've already heard a similar bill on this this year. That was SB 858 by Senator Hester. So the bills have some similarities and they have a few differences. So what I'm going to do today is just kind of cover just broadly and then the differences. So what this attempts to do is just say, look, you cannot take the likeness of somebody with AI technology and create like a revenge porn situation. And so with the advances in technology, this is becoming a real issue. You probably were seeing Taylor Swift had an incident with her that was all over the world. So the difference between our bill is our bill has lesser penalties than the Senate version. There's also the definition of deep fake in there, and the Senate version has a civil component to it. I will say that we are going to be in contact with Senator Hester's office, and we are amenable to consolidating the bills to the will of the committee, of course. So if there are some suggestions that the committee has, we're open to making it work for both the House and the Senate. And with that, I can appreciate your time.
We did, yes. So thank you very much, Delegate Pippy. We would most likely, since they're not direct cross files, we would probably conform yours to what the Senate did, but would like your input on that because that's our position, and I thought we produced a quality product. So that's probably the posture. That's probably where this is going, but want to invite you to the conversation before that happens. So
absolutely. And your district mate Moon kind of created my version. So we're amenable and we're open to the will of the committee, obviously, and hope we want to move the needle this year. So.
Excellent.
Excellent.
Thank you very much. All right. Thank you. All right. So that'll conclude the hearing. Thank you very much, Delegate Pippy. We will now go on. Okay. So Delegate Lehman is not here. We're going to go on to, let's go to Delegate Kerr and then partner. So I'm sorry. Solomon. But Lopez was here before Solomon, so Kerr was here before both of them. So let's go ahead and Delegate Kerr, you're up.
Thank you, Mr. Chairman. Good afternoon. Today, I bring you House Bill 1158, which is the state government attorney general publication of documents. Although it's undesignated, this bill is the cross file for Senate Bill 669, which this committee passed unanimously and this chamber passed unanimously. It's Senator Charles's bill.
Excellent. Thank you very much. All right, no questions. Thank you very much.
Thank you.
That'll conclude the hearing for House Bill 1158. We'll now go on to Delegate Lopez is next, and then Delegate Cardin.
Thank you, Mr. Chair and colleagues on JPR. My name is Delegate Leslie Lopez, and I am here on behalf of the Montgomery County delegation. I am also a sufferer of allergies, so please give me grace as I get through this very short bill, which is likely to be your most mundane bill of the day and perhaps the session. HB 1003 authorizes a plat in Montgomery County to be drawn, recorded, and maintained in an electronic form in a manner approved by the state archivist. Currently, these plats are recorded on Mylar, and that is the bill. Passed unanimously in the House delegation, the Senate delegation on the floor, and it's the result of a 7-month-long work group where 22 recommendations of a similar stature were made.
Excellent. Thank you very much, Delegate. Questions from the committee? All right, well, that'll conclude.
Appreciate your time. Thank you.
Thank you. That'll conclude the hearing for House Bill 1003. We'll now go on to Delegate Cardin and Weibel. All right, Weibel, you're up. Is Weibel here? There you go.
Thank you, Mr. Chairman. I assure you I'll be quick. It's good to be with you all. I am Delegate Weibel here to present House Bill 1308. The impetus for this proposed legislation is from an experience of a resident in District 2A in Washington County. This individual had fought and won a court battle defending title to his property after someone had prepared a deed recording an interest in real property over the deed of the rightful owner. The rightful property owner, once discovering the false recording, spent $80,000 in court costs and attorney's fees successfully defending the title to his real property. House Bill 1308 simply states that a person may not falsely record a deed or other instrument that the person knows contains false information. Doing so would result in a misdemeanor conviction and a fine not exceeding $500. What House Bill 1308 also does is to allow the court to award attorney's fees to either party in defense of a claim in regards to a violation of the code section. You've probably seen ads on TV advertising home title protection services. I can assure you the issue is real. The bill passed the House 134-0. I thank you and ask for a favorable report.
Excellent. Thank you very much, Delegate Weibel. Questions on the committees? Senator West.
Thank you, Mr. Chair. $500 as the fine?
I'm not a
And
fan of
misdemeanor. Would you be upset if we increased the magnitude of the crime? The idea that you're going to set about to record a false deed and try to take someone's title sounds to me to be a serious problem, deserving of much more than a misdemeanor and a $500 fine.
I totally agree with you, Senator. I'm not a fan of fines and penalties, but the more important part of the bill is it allows him to recover court costs.
I get that.
But he spent 80 grand. So no, I'm not opposed to that, but
okay. Thanks.
Thank you.
All right, seeing no further questions, thank you very much, Delegate Weibel.
Thank you.
All right, with that, that'll conclude the hearing for House Bill 1308. We'll now move on to Delegate Cardin with House Bill 1041.
Thank you, Mr. Chair, members of the committee. John Cardin on House Bill 1041, asking for your favorable report. This is not cross-filed. This bill came out of legislation from the previous years dealing with the hate crime statute. It does two very specific things and very narrow things. First, it defines disability so that when somebody makes a claim on disability in the hate crime statute, we know what we're talking about, which seems to be best practices from around the country. The other thing it does is it adds religion to the hate crime statute. Right now, Maryland has religious beliefs. However, I'll give you a simple scenario. Let's just say, for the sake of argument, you are in an intimate relationship with somebody. However, you are an atheist, you don't believe in God, but you were born Catholic, you were born Jewish, you were born Episcopalian, and you are being discriminated against because of how you were born. So I'd say to somebody, I'm in a taxi cab, and I say, with the person, and they say, and I say, oh yeah, I was born Jewish. You were born Jewish, and they kick me out of the cab right there and say, I'm never going to see you again, or whatever it is. I mean, we could talk about, I call it the Hitler test. If in fact, you were born Catholic, it doesn't matter whether you're practicing or not. If according to Hitler, you're considered a Catholic, and therefore he's going to discriminate against you. And therefore it should be, as it is in many other states, both religious beliefs and religion and state hate crime statute. That's what the bill does.
Excellent. Thank you very much, Delegate Cardin. Questions from the committee? All right, Senator Sidnor.
My examples were a little choppy. Sorry about that.
I'm not following you.
Sure.
Do you have another example?
I'll try and give you, I was trying not to be graphic, but
Please do. That's what you do here.
Okay.
Don't.
I've used myself being Jewish as an example. I am not a practicing Jew, for example. I am, but let's just say, for example, I'm not a practicing Jew. But I go and and somebody draws a swastika on my doorstep because they know that my parents belong to Beth Tefillah, even though I'm not a practicing Jew. So therefore, that would be a violation. I could claim it's a violation of the hate crime statute because of my religion, but I cannot claim it because of my religious beliefs, because I don't have any.
But if you don't have beliefs, then you don't have religion, right?
Well, but
if I could be born into a Christian household, if I don't believe in Christ, then I'm not Christian.
So
I'm not.
The suggestion is that swastika on my doorpost would not impact me because I don't have any religious beliefs. So therefore, I shouldn't feel threatened or in any way that somebody's going to come after me and maybe cause harm to me simply because I don't have any religious beliefs is ludicrous. I could say, uh-oh, they're going to come after me, and that's a violation of the hate crime statute. That would be the example. I could give the example as a Catholic. I give the example as a Hindu. Let's look at Hindus and Muslims who come from communities up in the mountains of India, who live in Maryland, and they're secular, but they come from a community where they are discriminated against by the different communities, where they torture each other or do other terrible things. And if one threatens the other because of the religion that they were born to, wouldn't we be able to prosecute them under the hate crime statute? Shouldn't we be able to prosecute them under the hate crime statute? That's another example. But the person doesn't believe it. But could he still be killed by his foe from, because of their centuries old,
So this is to deal with my belief that you are a participant in a certain religion, although you may not be.
Right. So but that's not religious beliefs. Religious beliefs would be.
No, I said my belief that you are of a certain religion.
Yes. Yeah, it would be from the perspective of the perpetrator.
Okay. And the other question I had with disability is with this new definition, is disability it's not defined in the current statute?
It's just not defined in the current statute, and it just says disability. And what does that mean? We had a debate over in the House side. We thought about amending it to a definition in the health general article. However, because of legislation right now under consideration here in this General Assembly that removes language, the language of mental retardation, we didn't want to include language that would include mental retardation when we're trying to eliminate that. So we just defined it by the federal definition, which doesn't include the term mental retardation.
And there's no case law currently, there's no case law that we can look to the definition?
There is, as far as I know, there's no case law about this as in regards to the hate crime statute. However, again, I mean, it was simply, this was simply for clarification. We had support from a number of different groups saying that this would help clarify.
Thank
you. If you look at the testimony.
All right, thank you very much, Delegate. All right, with that, that'll conclude the hearing for House Bill 1041. We'll now move on to Delegate Moon. Has been here majority, and then Solomon. He was here before. So Delegate Moon, and then we'll go to Delegate Solomon, and then Delegate Boyce. Rosenberg was here. He's not. He just left.
Good evening, JPR senators. Delegate David Moon with House Bill 612. This is a Montgomery County local bill that passed unanimously. It basically removes a requirement for a traffic and engineering study when the county undertakes to use its power to decrease a speed limit on a road. And it also repeals a ban on photo enforcement on these roads and changes it to you can't use photo enforcement in the first year that the road has had the speed limit decreased. The reason for this is some of these guardrails were put in when the assembly first started devolving speed limit powers to localities, and Montgomery was one of the first to ask for this. But since then, the county has undertaken a countywide complete streets program where they've designated certain types of roads to have certain types of speed limits in business districts versus residential versus rural. And so there's not really a need for a street by street engineering study anymore. They already did it for the whole county. And when Baltimore came in later and asked for the same speed limit authorities, they too had also done a complete streets plan. So the ENT committee now is waiving the traffic and engineering studies for those jurisdictions that already have a complete streets plan. And it would be sort of a moot point to make them do these. The county, that was that the bill was introduced, the county itself requested that we put in, we revisit the issue of photo enforcement. When we first did this, there was a ban on using photo enforcement on any roads where the speed limit has been lowered. But the county thinks that leaves them very little way to enforce in places that might actually have legitimate issues, and all of the other restrictions on speed limits, speed cameras still apply. So they asked us to put in this language that lets them do it after a year. So that's the bill.
Thank you very much, Delegate Moon. Questions from the committee? Senator Folden.
Just want to be sure we're on the right bill here. Because there's a couple Montgomery County speed monitoring.
So this one is House Bill 612.
Oh, okay. So good to see you, Delegate. I keep feeling like I have this same conversation, and this same conversation seems to always start with Montgomery County about speed cameras. So what Montgomery County wants to do is everything we've taught in driver's education for the state of Maryland will be different in Montgomery County, because Montgomery County went and they want to set up their own speeds for housing or for residential and business districts, which would be contrary to what's in state statute already.
It's an interesting question. I've actually, I don't disagree with what you're saying.
So somebody from Frederick County coming down,
you can look at this in many aspects of law, alcohol code, this speeds now. And there are other states that have undertaken a comprehensive rewrite of how they do this. And so what we are currently in the midst of is evolving sentiment. But it wasn't just Montgomery, it's Montgomery, Baltimore, St. Mary's, or Solomon's Island.
So
now Prince George's. And so I think and State Highway, frankly, already is beginning to diverge from the default state speeds. But it's an interesting question. And I do think one of the suggestions I made to the new E&T chair, questions, was whether there was an appetite to do a larger, more comprehensive redo.
So this bill would, and that would be something that would be the better discussion, because this bill would allow Montgomery County arbitrarily at this point, because there would be no need for a study.
Not arbitrarily. They actually, the study has already been done for the entire county. There's a couple 100-page guide. You can look up exactly, and the law says 15 miles an hour, but there's no 15-mile-an-hour roads contemplated.
Then why is that in there? Because that's exactly where I was going. 15 miles an hour is just, and it becomes a money grab.
It's legally allowed, but the county has not, in the complete streets guide they put out, the lowest they're contemplating 20 in a deep residential pedestrian neighborhood, but 15 is not anywhere contemplated.
This is legally allowing, becomes like legalized theft, because we're allowing Montgomery County to be a standalone, to change the speed limits that are currently in statute and law.
Not a standalone. That's what I'm saying. Solomon's Island, Baltimore, Montgomery.
This bill's from Montgomery County.
But we've already done it for those other jurisdictions. We've departed from the state speed limits for other jurisdictions. That's what I'm saying. You're right to flag that it's heading in that direction.
Yeah, it usually is surrounded about, I wish it were more about safety and less about the money.
I do believe in this scenario, they are not making this about the money, because again, they've contemplated countywide what certain speeds should be on certain types of roads.
I know you and I have always shared that similar mindset about make it about safety, not about money, but
I agree with you.
Here we come again.
I agree with you.
No, I appreciate, thank you for the answer.
Wondering where that was going, because I know Senator Fulton feels some kind of way about the unilateral speed limit drop. So I'm glad that was good. It was a good conversation. All right. Further,
it's a local bill.
Yeah, I hear you. Further questions for Delegate Moon? All right. Thank you very much. All right. Do we have a delegation letter? Senate delegation letter? I'll figure that out. We'll get it. Yeah. So that'll conclude the hearing for House Bill 612. We'll now move on to Delegate Solomon with 1032.
Thank you, Mr. Chair. And I have actually another local bill to present as well that I'll get to next. So appreciate the opportunity. For the record, Delegate Jared Solomon, and I'm here to present House Bill 1032, which would essentially codify and modify the tourist area and corridor signage program. This bill actually did have a cross file last year as we were working on it. It was actually assigned to the Senate Finance Committee. We worked on it with the Environment and Transportation Committee. It was a little bit of a mix up in timing this year, so it officially did not have a cross file, but Senator Zucker was a wonderful partner on it. And actually, this bill was brought to me. The genesis for this bill is because of a constituent who's sitting in the audience who owns the Urban Winery, which is now in District 18. I know the chair just stepped out, but it formerly was in District 20. And I know both of our delegations have had wonderful community events at the Urban Winery. And so the backstory of this program actually is that Damon and his family had applied for a sign. And many of you are probably familiar. These are the brown signs that are on the side of the roads that, point out, like in our community, we've got Antiques Row or a golf course or, a marina or a winery or anything like that we would see on the side of a state highway. The interesting fact about that is, despite this program still ostensibly being on State Highway Administration's website, so if you literally pull it up right now, you can see that there's an application process. The State Highway Administration and MDOT basically unilaterally decided to stop doing this program for almost the last decade. So Damon and his family had applied for a sign. The area he's located in Silver Spring is surrounded by state highways, Georgia Avenue, Colesville Road, East-West Highway, and then obviously we're not too far from the Beltway either. And he kept getting denied because unbeknownst to him, the State Highway Administration had just stopped doing the program. They were still accepting applications. They were still going through the process, but they were not actually putting the signs up or doing it. Right, didn't tell anybody. And it's because basically this program was operating off book. There was no statutory requirement for them to be doing this. And they just decided, frankly, because the program had sort of petered out a little bit, they didn't have the money for it. There were some conversations with Federal Highway Administration about the actual icons that were supposed to be on a sign. And instead of telling anybody or saying, let's figure out how to reinvigorate this program or actually codify it, they just stopped accepting it. Which, as I'm sure you can imagine, for many businesses across the state, and these are for attractions that we deem important. Also historic locations, tourist attractions, wineries, breweries, all things that frankly we invest in other forms of our state government. But that last mile to get some advertisement, to get some eyes on it, we weren't doing it within the State Highway Administration. So I actually worked really closely with now Secretary Addix, but he was the head of the Breweries and Distilleries Association. We worked hand in glove actually to design the legislation last year that basically codified the program as it was currently exist in sort of regulation. And I should have mentioned it's a partnership really between the Department of Commerce, who handles sort of the approval of whether an attraction merits a sign, and they have a whole series of requirements. There's actually a review committee, and then the State Highway Administration and MDOT on the other hand, which actually approves and permits theoretically the location of the sign, and it's on their right of way. We worked on it last year. Obviously, there was a new administration in place. They were kind of getting their hands around everything, and they said, let's work during the interim to try to figure this out. We've been working with them. The bill that's before you now is a little bit different than the bill that was introduced, and it's actually because we worked literally hand in glove with MDOT and the Department of Commerce. And the bill that was unanimously voted out of E&T, unanimous out of the House, comes over in a form that, again, we spent literally hours working with MDOT. And one of the issues we ran into last year was the previous iteration of the program, the signs were actually free. So there was a significant backlog of upwards of potentially $10 million worth of signs that were outstanding. Again, MDOT couldn't tell us how many of those businesses that had been approved for signs were even still in existence. And obviously, we all know the issues we have with our trust fund. So again, working with the community, with the business community, what we've decided to do is the bill is now essentially cost neutral. So a business would have to pay for the sign. And they will also be, we give the department the discretion to be able to charge sort of an annual fee to cover the administrative issues, but also the fee can be used in some respects to make sure that if obviously the business hasn't paid their fee, we kind of know maybe either they don't want the sign or maybe they've closed. And so it gives the State Highway Administration the ability to then take that sign down. And it'll also help cover some of the costs for the Department of Commerce. And, again, because there was no opposition to this bill, we didn't have a panel. But again, Damon is here. His winery is a wonderful business in District 20. Formerly in District 20, now in District 18. Sorry, Mr. Chair, we stole them. But they're still helping the greater Silver Spring community. He works with growers across Maryland, serves Maryland, other Maryland products. There's testimony that you can see in the system from, I know Senator Folden just stepped out, but the 10th Ward Distillery in Frederick. We've got a letter from the Allegheny Museum in Western Pennsylvania, and then the distillery, the Brewers Association. The other really important thing is, as before, the program was very limited in the types of businesses. And so breweries and distilleries were actually excluded because, again, the program hadn't been updated. So what we've done, the last thing I'll mention is the Federal Highway Administration. There were some issues with the old program because you were essentially putting logos up that weren't approved by the Manual of Uniform Traffic Code, basically. And so, yeah, Senator Muse, exactly. Learned more about this than I ever thought. And so what we've done is, like, Virginia essentially just puts the name of the business up on the sign with an arrow. And so we changed some of the regulations that are now hopefully going to be in statute if this bill passes to basically say if there is an approved graphic or logo that the feds have approved, because we don't want to put anything in jeopardy with our federal highway dollars, that logo can still be used. So like a golf, the little golfer symbol is something that's approved by the federal government. The grapes for a vineyard technically actually are not approved. That was, again, a wrinkle we discovered in our work with MDOT. And so this will give them the ability to just say, put the name of the business up if it's deemed appropriate by the Department of Commerce, and then the business will be able to fabricate the sign, get the permit and approval from State Highway Administration and put it up. So again, cost neutral, a really important way for businesses that we invest in so many other ways through our state budget to be able to get a little bit of attention, get much reduced cost advertisements essentially, and allow us to hopefully help them grow. So I would urge a favorable report, and happy to take any questions.
Thank you very much, Delegate Solomon. Questions from the committee? Senator Sidnor.
Just a quick question, because I was, as you were talking, I was trying to flip through to understand. This is for commercial businesses, or, I mean, who qualifies for this?
Yeah, so in existing code, or the existing sort of regulations that the program had operated under before, I'm just pulling it up so that I give you the full list. So the signage as before was visitor centers, golf courses, antiques rows, marinas, and wineries. And then the Department of Commerce had sort of a little bit of flexibility. They had a review committee, to deem other attractions that were significant or important. So it's sort of, we leave the discretion here, and this was again at the suggestion of the Department of Commerce, for them to work with essentially the tourism agencies across the state to deem an attraction something that would be warranted of directing folks to.
I appreciate it. Thank you very much.
Yeah, thank you, Senator.
Further questions from the committee? Well, Delegate, thank you very much for bringing the bill forward. The only problem with it that I can see is that Damon and Paris, y'all left D20, went to next door, but it's good to see you all. Is that new baby? Yes, sir. Congratulations. Thank you. That's awesome. Baby boy, girl? Girl. Baby girl. All right. Congratulations. It's good to see. Good to see you both. I'll have to stop in. I'll see you soon after session. All right. Thank you, Delegate Solomon.
I have a local bill actually to present as well.
Let's knock it out. Go ahead.
And maybe I should take advantage of it while Senator Folden is out. It is a speed camera bill. So I'll move quickly, but I will. Yeah, better hurry up. But I will start. This is House Bill. Make sure I get the right testimony up here. This is House Bill 665. It is again a Montgomery County local bill. This was voted unanimously out of delegation, out of both delegations, and I do believe you should have a letter attesting to that. Essentially what this bill does is it gives Montgomery County the ability to place speed cameras on high injury network or high injury corridor roads. So they are the most unsafe essentially stretches of roads within Montgomery County. So the HIN network covers about 3% of Montgomery County roads, but actually makes up 41% of serious and fatal crashes. So again, these are the most unsafe, where there's either been incredibly serious accident crashes or fatal crashes. And part of the reason that we designed it this way is the county currently actually does not have the authority to put speed cameras in certain locations with speeds below a certain point, and they don't actually have the jurisdiction to be able to put speed cameras in commercial roadways or in commercial districts on roadways. And so we worked on this bill last year and actually decided to modify it to just pinpoint this piece, because I know there's always a concern around, this is not meant to be a money grab. This is meant to be about safety. And we felt like this was a much more targeted approach. This was actually one of the top priorities for our police department and our county government that we worked in concert with them on. And again, this was voted unanimously out of both delegations. The only amendment that you have is something that was amended in the delegation, just to clarify. A handful of these roadways are within municipalities, I believe Rockville and Gaithersburg. And so we just wanted to make sure that the municipalities had the same ability as the county. And this bill contains sort of the typical protections for a speed camera bill that would that I know the General Assembly tends to look for. We do not have the money to sort of go back into the county's general fund. It is specifically targeted. Obviously, any cost above the cost of the actual camera has to be reinvested back into making this stretch of roadway safer. So again, the money from these cameras is going back to potentially retrofit or improve the roadway that again makes up the most serious and fatal crashes that we have in our county. So we'd urge a favorable report, and happy to take questions.
Thank you, sir. So this is a local bill, correct?
Correct.
And it only impacts Montgomery County?
Correct.
So it deserves local courtesy?
I would appreciate that. I think our delegation would as well.
Okay. Yeah, I definitely agree with local courtesy. I know there was a Prince George's County bill that came out of delegation, and Montgomery County didn't show the same courtesy. They added an amendment to a Prince George's County local bill. And so that's something I think should be taken back to the Montgomery County delegation if they want to have that same courtesy here in the Senate.
I will share that with our colleagues.
Just to be clear, that was the House delegation.
Yes.
Okay. Senator Sidnor.
It's funny that you say that because I know Baltimore County, we had a speed camera bill that was killed and essentially is being held up in E&T because of some things, but it's neither here nor there. But my question is, I'm not quite understanding what this does. I mean, in my mind, it works on cameras, you have schools on cameras, you have these residential cameras. What is this? And where does this fall?
So it's essentially the same thing. And I should have mentioned, we work with the State Highway Administration. They were comfortable with this bill. We made a couple of tweaks to it based on conversations with them that we had in the fall. So essentially, Montgomery County does a high injury network study analysis every 3 to 5 years. And they identify, and I believe it was submitted. And again, there was no opposition to this. So actually, I know Mr. Tipperary was here earlier on Delegate Love's bill. He oversees the automated enforcement program for Montgomery County, and he is the expert on this. But essentially, the county identifies the most unsafe stretches of road in the county. And again, they do that about every 5 years based on crash and fatality statistics. And so essentially this would give them the ability, again, working with the State Highway Administration or authorizing them on county roads where they have full control to essentially put cameras in those locations. Some of them they already can. And I believe it's of the sort of 50 most dangerous locations in the county, they have authority already to put cameras on maybe like 10 to 15 of them. And what this would do is if you have a location that happens to fall, let's say in a commercial district where they don't currently have the authority, they could put it in that high injury network location that falls within a commercial district. And part of the reason we didn't just say we want to give them blanket authority to put it in a commercial district or blanket authority to put it at speed limits below what's already in statute is because we didn't want to give them that blanket authority. We didn't want to expand it willy-nilly. We wanted, this bill is specifically on safety, and we wanted this to reflect the fact that these are the most unsafe stretches of road in our county, and this gives them another tool in their tool belt to be able to make the roads safer.
Is high injury or however you're terming this is that outside of this bill?
No, and let me tell you, just pulling up getting the most recent version up. So they say that have been identified in the county's most recent local strategic highway safety plan or Vision Zero plan as roadways or intersections that are high risk for motor vehicle accidents that result in serious bodily injury or death. That's the way that State Highway Administration asked us to phrase it. But essentially the county refers to them.
Where are you reading that from?
Oh, I'm sorry. That's the top of page 3, lines 6 through 9 of the bill.
Am I looking at the wrong bill?
At least in the version that I have.
You're looking at 612, right?
665. Sorry.
That helps me. All right. Gotcha. Thank you. Appreciate that.
Yeah.
All right. Further questions from the committee? Thank you very much, Delegate Tallman.
Thank you.
Excellent.
I was gonna say, happy to take questions from him if he has them.
All right, we've got, so I want to make sure we get Delegate Rosenberg, then Lehman, then Boyce, because there's in the order that people have been in. I know they're waiting in chamber, so Delegate Rosenberg's up next.
I have 2 bills. Which bill do you want me to take first? 128 crimes. Okay. If someone were to threaten me with physical harm or any other witness you've had before you today, that would not be a crime under existing Maryland law. It would be a crime to commit such acts for an individual who is testifying or appearing before the judiciary. So what House Bill 128 as introduced, copied from the existing law dealing with criminal interference with the judicial process, as now before you and as amended by the House, provides that if there's harm or the threat of harm to an individual
testifying or seeking to testify before the legislative branch, that would then be a crime. And specifically, this was prompted by a conversation I had with Delegate Kipke after a hearing in HGO about several years ago, an instance when the evening after some healthcare provider was testified in our committee, an insurer, I believe it is, contacted that person in an intimidating way. I don't want to get into the specifics because that's not before us today, but it's not purely a hypothetical issue. We already criminalize similar action regarding someone before the judiciary, and the bill has been pared down to apply only to physical harm, the threat of physical harm or actual physical harm, and the penalty is made less stringent than it is under the existing law for the judiciary. I am fine with the amendments and would seek a request a favorable report. Thank you.
Thank you for your testimony, Delegate Rosenberg. Are there any questions from the committee? Well, Delegate Rosenberg, if you don't mind, I have a question because I was removed from my comfort zone, which is all of my information in front of me, and I'm just not 100% certain I understand everything that you said. Under current law, your contention is that a threat of harm would not be a criminal act, even for us as legislators, and this bill would specifically designate a special class of legislators?
Well, as is the case for threatening harm, whether it's physical or not, or harming an individual testifying before the judicial branch, that this bill copies that law as introduced to apply the same create the same criminal standard for someone testifying before this co-equal branch of government.
And what's the criminal penalty that it calls for? And I apologize for asking, but again, I was removed from my.
3 years as amended.
Okay.
And it's 5 years for the judiciary.
And the amendments just take harm and add physical harm.
Correct.
So emotional harm wouldn't count.
Correct.
Okay, thank you. Any other questions? Well, that concludes the bill hearing then on House Bill 128. Delegate Rosenberg, you're next up with House Bill 1408, Residential Property Assignment of Contracts of Sale, Disclosure Requirements and Rescission.
Thank you. This bill deals with wholesalers of residential properties. I read about the problem existing in, I'm sure it's not limited to Baltimore City, but that's where I read about the problem, that the wholesaler is a middle party who will buy a property usually from not someone who's in the business of owning and selling properties, but a residential property, will buy it and then with the intent to sell it to a third party. And what the bill does with the support of all the relevant parties, this is the second year I put the bill in. Last year, we did not have that consensus. We do now, so that the wholesaler would be obligated to inform both the party from whom the wholesaler bought the property, as well as the party to whom the wholesaler subsequently sold the property, that this is the role that the wholesaler is playing in this process. The failure to do so would be cause for rescission of the transaction. So this is, I think it's fair to say, to characterize it as when not done the right way by the wholesaler in those circumstances, is preying upon, preying upon the seller originally, the purchaser secondarily. And the bill, by requiring notice and providing for the option of rescission upon failure to provide the notice, has achieved support from all of the relevant parties. So I would urge a favorable report.
Thank you. Senator West, you have a question?
Thank you, Madam Chair. Actually, I do. So I'm old enough to remember when the Rouse Company secretly acquired land in Howard County, which later became the city of Columbia.
Correct.
And it did through various officers of the company, one of whom was my uncle, as well as through other people. And they would go out to visit farms and owners of property in the general area, which now is Columbia. And they would engage in, they would get a contract of sale to buy the property. And then before the closing, they would transfer the contract of sale to the Rouse Company, so that ultimately the purchaser was the Rouse Company. And it was done secretly so that people knew that people were interested in the property, because there were lots of offers being made on property around there, but nobody knew it was the Rouse Company behind it. It was an incredible operation. And virtually all the land that now is Columbia was acquired that way. So my question is, would your bill have prevented the Rouse Company from acquiring Columbia by requiring the actual what was going on to be disclosed to the sellers? The reason why the Rouse Company was able to do it was because people sold the land cheaply. If they'd known the Rouse Company was trying to assemble all the land to create Columbia, the price would have gone up, and the Rouse Company couldn't have afforded to do it. So how would you react to that?
I would defer to somebody who knows this better than I do. I wouldn't want to guess. It would be a guess from me. And I think it's a legitimate question. I don't know if there's anything else in existing law that regulates those transactions independent of this bill. I don't know, but I would not want to venture a guess. I can certainly inquire.
Let me ask you this then. What is the reason? Why do we need this bill?
We need this bill.
What's the problem we're trying to solve with this bill?
The problem is because people were unaware that, well, I think it's fair to say it was similar to something that Mal Sherman, who worked with Jim Rouse, blockbusting, that a property is sold at a lower level, at a lower price to one party who has the intention then to sell it to another. And that's what blockbusting, how that took place. So this is, I'm not saying it's identical, but it is informing all the parties to the nature of the transaction.
Okay, understood. Interesting bill. I'm going to have to think about this one, but thank you for bringing the bill.
And I would add that the people who know better than I how this works are in support of the bill and available to
discuss,
testify today to be of assistance to the committee.
Okay, thank you very much.
Thank you.
Yeah, sure.
Thank you. Seeing no further questions, that concludes the bill hearing.
Thank you.
Next up, we've got House Bill 193, Delegate Lehman. Delegate Lehman? Okay, well, I'm glad I got you up then. I wasn't 100% certain.
Thank you, Madam Chair. Good afternoon, esteemed JPR members. For the record, I'm Delegate Mary Lehman, and I'm here asking your favorable report for House Bill 193. This is a local bill, and it is also enabling. It would allow the Anne Arundel County Council to adopt legislation lowering its maximum speed limit on certain roads after an engineering study to 15 miles per hour. It's modeled after the Montgomery bill that was presented earlier, the original version, I want to stress, that was passed in 2021, allowing Montgomery to lower its speed limits to 15 miles an hour after completing an engineering study. I want to assure you that this bill does not permit speed cameras in these lower, I think this will make some of you happy. It specifically excludes adding speed cameras to these roads that where the speed limit is changed to 15. So the reason for this really is about safety, especially for pedestrians and bicyclists, but also motorists and their passengers. Pedestrian fatalities are a serious problem in Anne Arundel County. They're on the rise. I'm sure you've heard these statistics, but to refresh your memory, the faster a car travels, the greater the chance there is for fatal injuries to pedestrians, bicyclists, passengers, and drivers. Data from the Foundation for Traffic Safety found a pedestrian or a bicyclist who is struck by a motorist driving 40 miles an hour is 8 times more likely to die than a pedestrian or bicyclist struck at 20 miles per hour. So the goal of HB 193 is to reduce injuries and fatalities and make Anne Arundel County roads safer by giving the county the authority to lower speed limits where it is warranted. Again, the bill prohibits the county from installing new speed monitoring devices in these reduced speed limit areas. So the state and most local governments in Maryland, including Anne Arundel, have adopted Vision Zero policies to eliminate car-related deaths. And this bill provides an important tool to help the county in realizing its goal. Additionally, the mandated traffic study provides an excellent opportunity for citizen input and concerns to be voiced. The bill did receive unanimous support from the Anne Arundel County House delegation, the Environment and Transportation Committee, and the full House. It's supported by the county executive, the Anne Arundel County School System, bicyclist groups, and AARP's Maryland chapter. I thank you for your consideration, urge a favorable report, and can take your questions if you have any, Madam Chair.
Thank you, Delegate. Any questions from the committee? That concludes the bill hearing. Thank you for your patience.
Thank you so much.
Next up, our final bill for the day. Last but not least, Delegate Boyce, please present House Bill 972.
Last, that means y'all gonna be nice to me, right?
Well, that's asking for a
Absolutely
lot,
not.
Delegate. This is
Absolutely
JPR.
not. I know. So, first of all, good afternoon. Madam Chair and members of the Judicial Proceedings Committee. For the record, I'm Delegate Regina T. Boyce here to present HB 972, Motor Vehicles, Off-Highway Recreational Vehicles, Clarifications and Revisions. I do want to point off by saying that there is no cross-file to this bill. The bill clarifies and harmonizes provisions regarding off-highway recreational vehicles, namely all-terrain vehicles, side-by-side utility vehicles, and off-highway motorbikes or dirt bikes. The bill does the following. Clarifies the definition and use of off-highway recreational vehicle to define recreational vehicles that are not permitted on the road throughout the transportation article. Clarifies and highlights the law requiring that an off-highway recreational vehicle must be titled with the MVA. All-terrain vehicles, ATV, off-road motorbikes, and snowmobiles purchased October 1st of 2010 or later are required to be titled. Side-by-side utility vehicles or UTVs purchased on or after October 1st, 2017 are also required to be titled, which is not the same as registration, to be clear. Highlights current law regarding the suspension of one's license for violating the use of a off-highway recreational vehicle, which is already law. The enforcement and reporting requirements, courts must notify the Motor Vehicle Administration if a child violates an off-highway recreational uses that is has prohibitions on highways. This ensures proper enforcement and reporting of violations, including minors, but the same goes for if there's an adult. Requires on receipt of notice from courts to the MVA regarding violation of the subsection of law and convicted, that the violators shall have their license suspended for 6 months on the first offense and 1 year for the second offense. The bill requires motor vehicle dealers selling off-highway recreational vehicles to provide electronic motor vehicle titling on the spot or at the time of purchase. And in the case that they cannot, they need to contract with a vendor to provide titling at the time of purchase. The bill retains provisions of certain off-highway recreational use in Allegheny and Carroll County, as it already is. I do want to talk about an additions added in the House for the bill. that specifies essentially that the bill allows local jurisdictions to enforce the Maryland vehicle law for violations involving an off-highway recreational vehicle, as well as enact local legislation to govern lawful impoundment of an off-highway recreational vehicle, for which the driver is issued a citation for a moving violation under the Maryland vehicle law involving the use of the off-highway recreational vehicle. Additionally, the bill enables local jurisdiction again to enforce the Maryland vehicles law, as well as it relates to reclaiming impoundment procedures. Detailed procedures are established for reclaiming off-highway recreational vehicles. Owners must be notified promptly, and failure to reclaim within 3 weeks after the date of the notice results in the police department ability to either further impound or sell the vehicle. For sale of an off-highway recreational vehicles are sold after impoundment, buyers receive ownership fees free of claims or liens, and they obtain necessary documentation for ownership, transfer, salvage, or scrapping of the motorbikes. I do want to bring up the chiefs stated they had some concerns with some clarifications with the bill, which I would hope the committee would take note of and help clarify. One is that the impounding provision does not currently apply if an off-highway recreational vehicle is abandoned. I would say that that would probably be up to local jurisdictions law, but I will let the committee make that determination. They speak about an ambiguity between the words individual, as in the off-highway highway recreational vehicle being belonging to an individual versus something that is titled. Or owner, they have it. They believe that the assumption is made that the individual titled is the owner of the vehicle. And I do want to mention that there is a secondary market issue with off-highway recreational vehicles. The vehicles are supposed to be titled. If I then decide that I want to sell my side-by-side to Madam Chair, then just like a car, I need to have receipt of sale and I need to provide you with the title. So then you can now have the side-by-side, for instance, titled in your name. That often doesn't happen. And so in this case, if, for instance, I sell it, I didn't give you the title, it's not titled in your name, but you have a receipt of payment. If someone is then using it illegally, or if it's found on the side of the road and it does have the decal sticker, it would say that I still owned it. And at that point, I would probably be contacted and then say, I actually sold that to Madam Chair, and they can probably provide that information to then go after potentially you. But that is some of the issue with this. And the other issue is that most people don't get these vehicles titled when they should be titled. And then again, the last provision again is they have a concern about the repeat violators and how to impose a penalty for that. And so with that, I would say that I thank you for your time and your consideration, and I welcome any questions, and I offer and hope that you can have a favorable report for this bill. And I'm sorry, I'm a little congested. Allergy season is kicking my butt.
To this bill, why no Senate cross-file?
I don't know, madam. I've just been working on it. This is my 3rd year working on it. So I do apologize.
It's just that it's kind of a heavy lift, and we hear so many bills and now we haven't heard it before, and it may be a lot to absorb. But I know that you'll avail yourself for any questions offline if there are one. No question? Oh, Senator Sidnor.
Thank you. I was just asking Senator West, I heard you, but I'm
sorry, can you speak up? I can barely hear you.
Sure, I heard you. I'm trying to listen. I was trying to listen real carefully, but I'm trying to understand what this bill does and why it was introduced. I mean, and the last thing, I think you were using the term
off-highway recreational vehiole, and that is
right. Are we talking about dirt? I've seen dirt bikes. So what are we talking?
So let me start. 3 years ago, then Delegate Cham brought forth a bill to the E&T committee about dirt bikes. I believe it's Hagerstown were having a huge issue. As the bill was drafted, it was literally just a criminalization bill. And one of the things about saying that you're going to charge somebody $1,000 or put them in jail, you got to catch them first. And nobody's chasing an off-highway recreational vehicle. It's not feasible. So I was tasked to bring folks together and talk about this. And in talking about this, one of the things that come up is one, that a law had already existed in 2006 by then, our Baltimore City actually delegation, that after the bill was amended heavily, allowed local jurisdictions to register and permit off-highway recreational vehicles. And so once we went through that iteration, what was then discovered is that these bikes are required to be, or these off-highway recreational vehicles are required to be titled. Most people don't title these bikes, and so
under current law, they're required.
No,
not
under current law.
So we're trying to
Right.
bring it.
So
they
this
have
bill
to
kind of
title it.
highlights all the things that should already happen. And one of the other issues is that within transportation code, it has been listed as different definitions. So what it clarifies is that an off-highway recreational vehicle are the four main vehicles that we're talking about. Is essentially a dirt bike, a side-by-side, an ATV, and I think there's one more. I'm drawing a blank. I do apologize. And so clarifying that that's what it is, because that is what MVA categorizes that. And so it's changing essentially the code to say that off-highway recreational vehicle means these particular vehicles. And then finally, in talking to folks, one of the biggest issues is that once sometimes they get these bikes, it's, you look up who is titled to, you can give back essentially the bike if someone comes to claim it. The other issue is that most law enforcement said they want to have the ability to impound, and rather than make us be the individuals at the state to do it, we repealed that 2006 registration and permitting and instituted the ability to have local jurisdictions just be able to enforce the Maryland vehicle laws at the local jurisdictions, and then being able to come up with their own lawful impoundment laws as it relates to off-highway recreational vehicles. And I do want to say this because there is some questions about legality and illegality. Off-highway recreational vehicles are legal to purchase, to title, and to use in the places for which they are allowed to be. They become illegal when they are on the road. And so I do want to make that clear distinction. And so what this is doing is highlighting what current law already speaks about regarding this, as well as clarify definitions, and then provide that allowance to local jurisdictions to be able to enforce the motor vehicles laws, as well as create laws to create impoundment in those local jurisdictions.
And if the owners of the off-highway recreational vehicle doesn't title, what's the penalty there? What's the penalty for that?
I can't hear you. So
what's the penalty if you don't?
The penalty is not in here. It is $35 to title, and then $5 for a decal.
And if you don't?
You will be asked to do so.
So it's no criminal penalty?
No, sir.
No impounding?
No, but through this legislation, a local jurisdiction may decide that their impoundment laws could include a bike that is not titled.
Okay, so I don't title my dirt bike, or I'm sorry, the off-highway recreational vehicle.
Mm-hmm.
Nothing happens to me?
Currently.
I mean, under your bill, what happens?
What's that?
Under your bill, what would happen?
Nothing at this point. One of the things that we're trying to do is make it, again, it seems to be unknown. So what this bill does is make the individuals who sell these bikes title them at the point of sale, rather than you leaving and then not titling. So it's their responsibility not only to tell you, but to title it. If they can't title it, they need to have a contractor, like, those tag and title places to contract with to title the.
So this bill is about placing the onus on the sales
The sales as well as those who purchase.
Okay, you had just, you had said that,
I'm telling you the different parts of the bill that
Okay.
help folks remember that these vehicles need to be titled. So there is a dual responsibility
Gotcha.
here.
okay.
I'm
Thank
sorry.
you. No worries. I appreciate it.
You speak so soft, I can't.
I do, I'm sorry.
Thank you. Senator McKay, followed by Senator Folden. Senator McKay.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. The Maryland Off-Highway Alliance had suggested a couple amendments, definition of what a off-highway motorbike to high.
Yeah, they mentioned that. I think when the committee and the council took it up, they didn't see a strong correlation between what they said. I think they said the EPA or something defines.
Yeah, it actually, it would coexist with the national standards set by the EPA when it talks about all-terrain vehicles and those type of stuff. And make sure that the federal and state language regarding OHV terminology should be identical. So maybe it's something we can talk offline, but I think
We could talk
that's what
offline. I
we
think
did.
the committee looked at it, well, the subcommittee, I should say, looked at it and didn't feel that it was strongly helped or hurt the bill.
There's another bill that actually creates an OHV board in the DNR. It's going to be advisory, and actually the OHV community does support the tagging of them and all that kind of stuff. Because actually, we're looking at retaining some of those funds to help with creating trails and some different things there. So I'll discuss with offline.
Sure, absolutely,
and
Senator.
Probably make some amendments and that kind of stuff. And from a, let's hope we can get this thing through this year.
Sure.
But if we can, I'd be glad to be a Senate sponsor.
I hope we get
for
it
you.
through.
So
I hope I don't have to bring
do
this
that.
next year.
So.
No.
Thank you, Senator
Thank you.
McKay. Is that it? Senator Folden?
Thank you, Madam Chair. Hey, Delegate, thanks for bringing the bill.
Yes, sir.
I just wanted to ask, so Senator Sidnor brought up some points about, the attempts of this bill to have, but the one overwhelming thing that there's one primary reason people don't title a vehicle, especially if they're buying it secondhand, not from a dealer. And I mean, do you know what that would be?
No, you gonna
They
tell
don't
me?
want to pay taxes on it. They don't
yeah,
want to pay
no.
taxes on a secondhand purchase, especially, and that's why a lot of people go out of state to buy these that maybe Maryland doesn't have reciprocity with, because I don't know, you're gonna be shocked to hear this, but Maryland has a lot of fees and taxes. And these whatever they are, OHRVs or whatever. I just know that so I'm just kind of curious, is this bill doesn't do anything to still resolve that at this point?
No, and I would say that is not what we have heard when it comes to the secondary market, is that 9 times out of 10, there are a lot of folks who don't know that these vehicles need to be titled. And that's not registered, it's just titled.
Well, but when you title it, they pay taxes.
I understand that, but what I'm saying is that's not, and I appreciate that comment. I made a note of that. Is that is not what I've heard to date. Is just that more often than not, people don't know that this is something that is they're required to do, and then again, because they don't really understand that. They don't understand that you have to also transfer the title. But
Yeah.
I am taking
no,
your
I
point
understand.
seriously about
Nope.
not paying taxes, but that has not come up to date. But I
Okay.
appreciate it.
All right. Thank you.
You're welcome.
Thank you very much. Seeing no further questions, that concludes the bill hearing on House Bill 972. Thank you,
Thank you
Delegate
so
Joyce.
much.
And that concludes our bill hearings for today. I'm going to ask the committee to take a short recess until our chairman returns, and I'm assuming we have 4 vote lists on our desk. Hey, 3, okay. All in favor of doing it tomorrow, say aye.
Oh, I think that's binding.
I'm sorry, I overruled.